Parliamentary Joint Committee on Corporations and Financial Services into ethics and professional accountability, structural challenges in the audit, assurance and consultancy industry. I begin today by acknowledging the Ngunnawal and Ngambri peoples, the traditional custodians of the land on which we meet, and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via teleconference and in person. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It's also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind any committee members and witnesses who are appearing via video conference and who are not speaking to mute their microphones. I now welcome Ms Meredith Beattie. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Meredith Kim Beattie, former General Counsel of PricewaterhouseCoopers.
Thank you very much, Ms Beattie, and I'll go to Senator Scarr immediately for questions.
Thank you. Thank you, Chair, and thank you for attending again, Ms Beattie. And I note we had some discussion last time about the circumstances of your attendance, the need for the committee to issue a subpoena, the reasons for that, and from my perspective, I think you have acted entirely appropriately in relation to managing the issues you need to manage as a former General Counsel. So thank you for coming along once again.
Thank you, Senator.
I understand you've got a transcript of the hearing in front of you from Friday 2 August 2024. What I would like to do is go through some of the responses we got from Mr Seymour and Mr Sayers in particular in relation to the evidence you gave, and provide you an opportunity, I think, to clarify, to flesh out any particular matters in the context of the responses which they gave, because they had the benefit of appearing at the hearing after you appeared. So I think that's a fair thing for us to do. At the outset, I might take you to page 38 just to set up the discussion. And on page 38 at the top, we were talking about the institution of a strategy or a process, whatever you want to call it, under which legal professional privilege was claimed in relation to documents. There was then notices received from the Australian Taxation Office and contention as to whether or not legal professional privilege had been correctly claimed in relation to documents, whether or not the protocols of the firm had been followed, whether or not the terms of letters of engagement had been adhered to, etc. In that context, if I can take you to the third paragraph from the top, you said, I would probably frame it differently if I may with respect. I think the issue is, who was it within PwC that chose or permitted the practice or parts of the practice to proceed on a basis that was inconsistent with, contrary to and in breach of the firm's protocols and the legal engagement letters? I then asked you, who was it? And then you responded, the leader of the tax group at the time was Mr Seymour. In the first instance, that's your evidence. That's still your view, as you've had the opportunity to reflect since you gave evidence to us. You stand behind that testimony?
Yes, I do.
Okay. I'd now like to take you to page 61 of the transcript, and this is where the committee had the benefit of Mr Sayers and Mr Seymour appearing, both former Chief Executive Officers of PwC. Mr Sayers was the Chief Executive Officer immediately prior to Mr Seymour being elected as Chief Executive Officer. I take you to the middle of the page. You'll see there's a paragraph that starts specific to your question. Do you see that paragraph?
Yes, I do.
And then if you go to the middle of that paragraph, I'll quote for the benefit of Hansard. A huge amount of effort went into the firm to try to get that right, which Ms Beattie referred to. And in this context, it was the document production to the ATO. I'd have a very different view, frankly, as to the process around that. The document production process was run by Officer General Counsel and lawyers from the start. Ms Beattie referred to the fact that it was run by the tax group for the first year or so, and then the legal group came in and redid it. I don't believe that is factually correct. It was run by the legal team, end quote. Could I get your response to that, please?
Certainly, Senator. And I think Mr Seymour may have been inaccurately referring to my evidence. I did say that there were some people from OGC, a senior lawyer who was involved in the parts of the production process, but that it was run by the tax group at the time.
So it's your evidence that Mr Seymour's testimony in this regard is incorrect?
Yes.
Okay, we'll move to the next paragraph. That said, quote, that said, what the document production process did demonstrate is that in certain instances, a limited number of partners in the tax group had not followed those protocols correctly. That did happen under my leadership. It certainly wasn't something I condoned or was aware of at the time, but it did happen when I was the leader, and I accept accountability as leader that it happened on my watch. But immediately on becoming aware that those protocols hadn't been followed, which did come out through the document production process, it was one element of challenge around the document production process, not the only element. When that became evident, I, together with the leadership group at the firm, worked extremely hard to rectify that. A large part of that was a challenge with the legal process of delivering those documents, end quote. So my interpretation of that evidence, which Mr Seymour has given, is that A, he does accept accountability as leader of a team for things which members of the team did. However, he says that he wasn't aware that the issue had arisen, and as soon as he became aware of the issue arising, he immediately took action to rectify the matter. How do you respond to that testimony?
Senator, perhaps I can go back to some facts, and I may have referred to this in my earlier evidence, I can't recall now. From around late 2016, maybe 2017, the ATO was raising very significant issues in relation to the production process that had been started to be provided by the firm. And they were raising significant issues at that point about the privilege claims that had been made. So it was an issue that was live from around 2017. At some point, I asked that it be raised with the tax group whether there was a privilege issue that was arising, because the instructions that had been provided at that time were very clear that these were legal engagements and there had been compliance with the firm's protocols.
Sorry, the instructions from whom to whom?
The instructions came from the tax group.
Thank you.
To
PwC?
From the tax group to the external lawyers and the internal lawyers, that the services had been provided in accordance with the legal services engagement and in accordance with the firm's protocols.
And those lawyers to whom that communication came, they were under your guidance?
They were external lawyers. They were the external law firm that was working on the production process in answer to the notices that were being received, but the collation of the information and the instructions as to its characterisation came from the tax group. So the issue as to the privilege point was raised squarely by the ATO from, it may have been 16, but I think probably 2017. And at some point I raised a question, are we certain, like are people certain that the tax group has been operating in accordance with the protocols and in the right way, because why is this becoming a very significant issue? And it continued to be a significant issue throughout 2017. I was told that, and I understood it to come from Mr. Seymour, that the firm had been operating in accordance with the protocols and in accordance with the terms of the legal services engagement, and that any suggestion that they might not have been was not paying due respect to the role of the lawyer, who was the tax lawyer, providing the advice.
Can I clarify one thing? Because I'm still not sure that I understand if there was a lawyer from PwC embedded in the taxation section.
Within the...
Because you're talking about an external lawyer, but I don't believe...
Both.
Yeah, I don't believe that there would have just been an external lawyer to tax. So what have you done?
So within the tax group, of course, there are some lawyers who provide tax advice. That they're not part of my group. They are market-facing lawyers who provide tax advice. And that was the issue that arose in relation to the privilege.
And you had no supervision of those lawyers at all?
No, they are...
And there was no one under your area of responsibility who was engaging with them?
No, all of the work that was done by those tax lawyers in giving the tax advice that was the subject of review by the ATO were a separate group that were under the supervision, or for whom Mr. Seymour was responsible. They were not lawyers providing an internal firm function in the form of OGC.
Okay, so I understand. Did the subsequent process which you participated in, or the Office of General Counsel participate in, indicate that the views of those lawyers who were outward-facing within the tax group were actually incorrect?
It was...
In some cases?
Yes, it was that the instructions that had been provided to the external lawyers who were doing the production in answer to the ATO notices, that there had been privileged or legal engagements entered into, were incorrect, because what the firm's protocol required and what the legal services engagement required, as you would expect, Senator, was that the lawyer was the one who was running the engagement, and that the work that was done was created for the dominant purpose of legal advice. So a privileged, a legal engagement.
Understood.
And what was shown when we came to review the production that had been given in 2018 was that the lawyer had not had significant involvement at all, such that the engagement had not been conducted in accordance with its terms or in accordance with the firm's protocols.
So, Ms Beattie, it seems to me, and that's a very helpful explanation, that an inherent flaw or cultural flaw in that process is you had a lawyer internal to the tax group within PwC who was presumably reporting to Mr Seymour, is that correct?
Well, the head of tax risk and quality was the person who was running the day-to-day process, and he was, yes, reporting to Mr Seymour in relation to the production. When we got to 2018, and I think I may have given evidence of this on the last occasion, in around April 2018 there was a very significant letter that was written by the ATO raising very serious allegations against the firm about the use of privilege. And it was actually at that point in time that I was able, and it was after involvement of the Governance Board and others, to review some of the production that had been given. And so I think I looked at 2 productions in relation to either 2 or 3 clients that had been given. I worked back and I worked out whether it was a privileged engagement. I went and looked at all of the source information, and I created a template, if you like, of how you would assess whether privilege existed in relation to things. As a result of that, there were additional productions given to the ATO so that the firm was compliant with its obligations to meet the notices.
Okay, I want to take you to page 63 of the transcript. and we explored with Mr Seymour whether or not concerns you had with respect to claims in relation to legal professional privilege had been voiced to you and the discharge of his responsibilities. He made, I quote Hansard, "It's fair to say, Mr Seymour, it's fair to say there was tension between me and Ms Beattie through that process. I was frustrated with the legal process, that it wasn't going quick enough and we couldn't deliver the documents faster and get them delivered to the tax office. I had a view we were being too legalistic with the document delivery process in a general perspective. Really, that pressure and all of those dialogues commenced in and around 2018 as we were getting into the document production process." And this is the next sentence is the important one from my perspective. "Concerns had not been raised with me by my risk teams or Ms Beattie or Office of General Counsel in relation to the protocols on legal professional privilege prior to that date." End quote. Is that correct?
No, that is not correct.
What is, how, well, this is your opportunity to respond.
Certainly, and as I said sort of earlier today, it had become apparent that the ATO was raising issues in relation to privilege. This was not an issue that came out of the blue in 2018. It had been raised throughout the process, and it was reviewed, and issues were raised that this is problematic. There is a problem, and Mr Seymour was made aware of it.
So why would he say that? You can't go to motive, but I mean, it is striking that there's such a discrepancy between your evidence and his evidence.
I can't explain it, I'm sorry.
Okay.
Can I ask just a listing of when you say the matter was raised with whom?
So the matter about the privilege issues were a constant source of discussion as they were raised by the ATO.
With whom?
They would have been, I'm trying to recall now, they were in correspondence, they were the subject of meetings.
But correspondence to whom? Because Mr Seymour says on page 62, "No notice was served on me to deliver documents at any stage." On whom were the documents from the ATO delivered?
Oh, the notices were served upon Mr Khalija. Mr Seymour was well aware of the notices that were served because they were served on Mr Khalija, who reported to Mr Seymour. It was a source of great pressure for Mr Khalija that he had these obligations to respond to the notices, and Mr Seymour was fully briefed on a regular basis in relation to this process.
Okay, thank you. So thanks for that evidence. That's clearly put the two competing views on the record, I think. I want to move to the next issue, the second issue I wanted to quickly cover, which is in relation to, and Senator O'Neill might have follow-up questions on these matters, in relation to the process by which Mr Seymour's candidacy as Chief Executive Officer proceeded. And you provided us evidence that you understood after a telephone meeting that you'd had with Mr Sayers and the Chair of PwC Australia that Mr Seymour's candidacy was not going to proceed, and that you had given legal advice in relation to the Mr Seymour's candidacy proceeding. I wanted to put to you that Mr Sayers, I mean, he commented favourably on your integrity, but he couldn't recollect your having given any advice in relation to whether or not Mr Seymour's candidacy should proceed.
And Senator, I may be wrong, but I think my evidence on the earlier occasion was that there had been a board meeting on the Friday about at which the recent discussions Mr Sayers had with Mr Hirshorn had been shared with the board in the context of the board's impending consideration of which candidates would go forward as a shortlist for the CEO election. And there was then, and I think the evidence I gave was that I left that meeting expecting that the board would come to the view that it would be difficult, or that Mr Seymour would not not proceed through to the next round of CEO selection. There was then a call on a Saturday. It was around the middle of the day. I was on the call, Mr. Sayers was on the call, and the chairman was on the call. I remember it as quite a forceful discussion about the matter, and as a result of that, the call ended on the basis that Mr. Sayers would go and speak to Mr. Seymour.
Why do you describe it as a forceful conversation? How was it forceful? That's a very particular word you chose.
There was a very robust expression of views, I suppose, with Mr. Sayers talking about the issues that had arisen with the ATO, the problems that created, and that this was a significant issue that needed to be considered. I remember it as quite a robust call with the chairman.
Was it robust from your perspective? Were you robust?
Yes. Normally, if I would attend a meeting with the CEO, of course, I would let the CEO lead the call, but then I would come in and add, support, suggest, whatever my position might be, and I certainly supported Mr. Sayers' position in relation to the position that was being put about Mr. Seymour.
So the indication I'm receiving from this testimony, Ms. Beattie, is that Mr. Sayers, in fact, had doubts as to whether or not Mr. Seymour's candidacy should proceed. He was actually advocating his doubts or expressing those serious doubts to the chairman of PwC. Is that correct?
Yes, he was expressing concerns about how you could deal with issues that had been foreshadowed by the ATO as problematic. So my understanding of the discussion that Mr. Sayers had with Mr. Hirschhorn, and I think it was the Thursday before the Friday board meeting, but it may have been the Wednesday. I don't have the exact dates. My recollection of what occurred at that time was Mr. Sayers called me shortly after the discussion that he'd had with Mr. Hirschhorn, and he expressed he was surprised at the tenor of the discussions he had had with Mr. Hirschhorn in terms of Mr. Hirschhorn's concerns about Mr. Hirschhorn's concerns about Mr. Seymour, and that in that discussion, Mr. Hirschhorn had raised the fact that it would be problematic if Mr. Seymour were to become the CEO of PwC, because he would have a conflict issue that Mr. Gregory would not have if Mr. Seymour were to become the CEO. And my recollection was that was against a background of Mr. Hirschhorn mentioning to Mr. Sayers a number of issues that Mr. Hirschhorn had in relation to the firm, but it was particularly with a focus concerning Mr. Seymour and the implications that could have for him if he were to become the CEO.
Was your impression that Mr. Sayers was advocating a position that Mr. Seymour should withdraw from the process?
My understanding of Mr. Sayers' position was that he was urging the chair to consider this very carefully because of the issues that had been raised by Mr. Hirschhorn, and that it also raised a consideration about how this could in fact be managed if Mr. Seymour were to become the CEO and if the conflict position that Mr. Hirschhorn had foreshadowed were to arise.
And those all seem very legitimate points from my perspective. Mr. Sayers, and this is my last question, Chair. Mr. Sayers said halfway through page 64, if you can go down to 64, and I'll just read this. There were lots of conversations at the board with regard to the feedback from the tax office, the 2017-18 period that caused such grief and so many issues, and the huge amount of change and work that was done between 2018 and 2020. And then there's this statement, which I'm seeking your input on. On balance, the governance board made a call with input from Global. What input from Global was there?
I don't know. I can only tell you what I know eventuated after the call on the Saturday that I've mentioned. I did speak to the CEO's Chief of Staff, Mr Collins, on the Sunday, and he recounted to me that Mr Seymour had been very unhappy with the way in which these issues had been flagged by me. I then received a call on the Monday, and that was from the then Chief Risk Officer, Ms Nadia Carlin, who advised me that the selection committee, which was a subcommittee of the governance board who was determining the go-through candidates, had decided that Mr Seymour would go through to the next round.
Okay. Thank you, Ms Beattie. As I indicated, I have to apologise. I've got another committee I must attend. So thank you, Chair.
Thank you very much for being here, Senator Scarr. I will come back to pick up the threads of some of the questioning there, but if I can just firstly thank you, Ms Beattie, for replying to the question I noticed that you noted from the evidence.
Thank you.
I also, particularly given the nature of the clarifications that you have been able to provide with some certainty, which is quite different from the evidence we received from Mr Sayers, where he stated on a number of occasions that he could not recall, he could not recollect. Relying on your more clear memory based on the evidence we've received so far, I would ask you to review the evidence of the 2nd of August. There are a number of matters that were declared by your colleagues. You have the transcript in front of you. I invite you to correct the record on anything that was said in there that doesn't accord with your recollection of those matters. So it's quite a bit of evidence from your colleagues. Is there anything that you wanted to say immediately that you want to correct?
Senator, I think there was a lot of discussion around 2017 and 2018 and what occurred at that time, and I think, and perhaps I'd like some time just to actually go back and look in detail, but I think one of the things that Mr Seymour mentioned was his concern that it had been left to others, and I think the implication was OGC, but he may have been more express than that, that in 2018 people hadn't reviewed whether Mr Collins had entered into a confidentiality agreement. And that was in, of course, the context of the Tax Practitioners Board matter. Mm. And
that is disputed by other evidence, and there were some corrections to the record about an email, I believe, that occurred in 2016, which was subsequently described as having been missed.
I'm not sure what that's...
We'll provide you with that response as well, which does, in a minor way, but perhaps significantly, given your knowledge, correct the record about when communications were
But certainly,
made
apparent. And I hope I'm not digressing here, but certainly in 2021, when the firm received the first letter from the TPB, and so that was dated the 8th of March 2021, I think I received it on the 10th of March 2021, and I learned on or about that time that Mr Collins had already received a letter in January 21, although I hadn't been made aware of that, and that letters had also been provided to 2 other retired partners indicating an investigation. At that time I spoke to the partner I reported to, Mr Gregory, who was head of strategy, risk and reputation, and I asked him if he would like me to provide the documents to the chair, and I also had an engagement with Mr. Seymour in which I said to him that I had provided the letters from the Tax Practitioners Board to the board chair because of the very significant nature of the allegations that the TPB had made, which against the firm that it was investigating. So at the 8th of March, they were investigating whether the firm had failed to act honestly and with integrity, whether it had failed to act lawfully in the best interests of clients, whether it had knowingly obstructed the proper administration of taxation laws. So these were very significant matters. And they also indicated in their letter of the 8th of March that they were looking at a partner who became Mr. Collins, but they were also looking at the conduct of a number of other partners and employees. So I spoke to, or I let Mr. Seymour know that I had provided information to the chair because of the serious nature of the allegations or the nature of the foreshadowed investigation. And he at that time said to me, I want you to confirm urgently whether Mr. Collins signed a confidentiality agreement. The tax group risk partner had looked at this previously when the issue was raised with Mr. Sayers, at which time the tax group partner had confirmed that Mr. Collins had not signed a confidentiality agreement. Mr. Seymour said that the firm now needed to reconfirm this as it had a clear impact on the next steps. So to the extent that there was an impression in some way that was an issue that had been dealt with by OGC, certainly as at 2021, Mr. Seymour's belief was that it was an issue that had been dealt with by the tax group as to whether there was a confidentiality agreement for Mr. Collins.
Okay. You were reading from a document then, Ms. Beattie?
Yes, I have. It's hard to remember all the dates, Senator, of everything that has happened. So I had prepared a very short note that just gives me dates and different events that have occurred throughout. It's very much an aid memoir for me, but it is something that sets out some dates and some things that had occurred to try and make sure that I was able to assist the hearing in a more efficient way than might be the case of me trying to sit here and remember which date was when.
Thank you for undertaking that preparation. It probably would be helpful for the committee to have a copy of that. Thank you. You indicated just then that there were a number of other partners that were mentioned in the letter, the correspondence from the TPB to you. You indicated that Mr. Peter John Collins became known as the main person.
Yes.
Were other partners named in that correspondence who were being investigated, or was just an indication that investigation was alive?
The letter stated that the TPB was conducting an investigation into the personal conduct of a registered tax practitioner who came to become Mr. Collins, and making inquiries regarding the conduct of other partners and employees.
Great. So no names, just an indication of continuing inquiry.
No. Although subsequently the firm received, at the time that it received this letter, I believe it also received a notice. Yes, it received a notice that was seeking information and documents. So it was a formal, I think it's a section 60-100 notice, and in there were references to personnel who had confidentiality agreements, some references to secondment agreements, so it was quite a broad, I think it had something like 120 sub-questions in it, so it was a document that required answers. Ultimately, that notice was withdrawn by the TPB, and it did not proceed, as I recall it, with a further notice against the retired partner. There were two retired partners who had received notices, and one of those retired partners, I understand, provided a response to that early notice, and another retired partner did not. And as a result, the TPB withdrew the notice against the firm and against the one retired partner. And then it issued fresh notices, I think in July 2021, against the firm and against Mr. Collins.
Could I ask if the list of people who were dismissed was constructed on the basis of information that was provided to you by the TPB or by some other means?
Sorry, may I ask the question? Could I ask that you repeat the question?
So my question really was, there was a list of people who ultimately were dismissed by PwC. Were any of those people identified to you by the TPB, or were they identified by other internal processes, Ms Beattie?
So I think the question is, when people were retired or left the firm in 2023, is that the question, whether they were the same people that were mentioned? Yes. I would have to look, I think I would have to take that as a question on notice. I would have to look back at the 60-100 notice and see what it identified. And it didn't identify people in breach. It identified people who had confidentiality agreements. It identified some people who had secondment agreements, and it asked a range of questions in relation to them.
So I'm asking you to, because you have access to that list by the answer that you just gave me.
I have access to the 60-100 notice, yes.
Okay. The committee will certainly be interested in that document and any other documentation that you have to help us understand who was identified and then ultimately who was dismissed by PwC, and see what the overlap was. Is there overlap there, Ms Beattie, or were people dismissed because of different reasons? Were other people located in the course of your inquiry? And so you subsequently dismissed different people from those who might have been identified by the TPB with regard to confidentiality?
I wasn't responsible for the decision about the people who were dismissed in 2023, although I did have an earlier role in relation to some discussions about it.
Did you assist with the preparation of a list for consideration of who should be dismissed and the reasons for their dismissal? Yes, there was early. Senator, you may recall that there was a two-stage process where my recollection is, and I don't have access to this information, that the firm put some people on leave while it investigated certain things, and then it made a determination, I think, in early July about those who would retire from the firm. I was certainly involved with others, and it wasn't my decision, but I was certainly involved with others as there was an identification of those who may be put on leave while certain matters were looked into. Okay, so the people who were put on leave is now really a matter of public record. Senator, I just can't recall exactly who they were. I would have to sit and put myself back into that time. I can't recall at the moment, but I can certainly look at it. If you can take that on notice. Certainly. I'm interested in who was put on leave and for what reasons, because there's been an embedded assumption that might not be correct, that the people who were put on leave are people who were intimately involved with the Peter John Collins matter or the LPP matter. Were people put on leave for any other reason, or was it exclusively people related to those two matters which are, of interest to this committee? Chair, I think it's difficult for me to answer that question in an open forum, and the only reason I say that is I am aware that there is litigation, I think, on foot, or disputes on foot in relation to some of those individuals. Indeed. And that is why I'm asking the question, because there has been the public naming and dismissal of some people, and there has been a sort of retributive action by those individuals who either saying that they were unfairly dismissed, or there have been settlements. So I'm wondering about who was dismissed. Were they the people actually intimately involved with the Peter John Collins matter through the that the TPB made us aware of, and or the LPP matter, and or the Foreign Investment Review Board matter, or were they dismissed for other reasons conveniently at this time?
And Senator, I'm trying to think how I can best assist. I suppose if it would assist the committee, what I can do is look at those who were dismissed and provide, in answer to a question on notice, whether they were involved in the TPB matter, whether it was because I don't know ultimately the reasons, but I can tell you what their role was with reference to the issues you just mentioned.
The confidentiality matter, the TPB
Yes.
matter, the LPP matter, the Foreign Investment Review Board matter, any other matter?
Yes,
Take that on notice.
I'll take it on notice.
And we may yet go in camera, and that might make things a little easier for you at some point in time. But as I said last time, this matter is of such interest to the public, and because of the critical role of PwC and its confreres in that space, it's important to get as much of this on the record as possible.
And I do understand that, Chair. It's a difficult.
And you accommodated it. Thank you. So let's indicate that we might come back to that on notice if you can, Ivan. Can I go to the detail of the file note that was made available to this committee by Mr. Hirschhorn? Again, relying on your recollections, any materials that you may have in your possession, Ms. Beattie, because it seems that you have some documentation but not others.
No. Chair, when I left the firm, I did not take any documents from the firm with me. That would not have been appropriate. For the purpose of preparing before my appearance on the 2nd of August, I asked the firm if it could make information available to me, and they did make available to me some information, but not all information. My recollection, and I think the meeting you're referring to is the meeting between Mr. Sayers and Mr. Hirschhorn on or about the 29th of August.
Correct.
I think 2019, I think
Yes.
is the meeting. And
which subsequently had a brief prepared on it to inform the discussion at the board.
And I don't have a copy of...
Nobody seems to have a copy of that, Ms. Beattie, so that's pretty interesting.
Oh, well, I don't have a copy, and I don't know. I believe... Well, I don't know whether there is a document. I don't have the document and I can't recall. I believe...
Would it be normal for documents that are prepared for the board to just disappear like that, Ms. Beattie?
Not if it was handed to the board. If it was prepared for the board, there would be an expectation it would form part of the board records.
That's what I thought. So I'm a little puzzled as to why that document can't be found.
I can't comment. Sorry, Chair.
Thank you. So on notice, could I ask you to have a very close look at Mr. Hirschhorn's contemporaneous note and ask you to compare that note with your recollections of your conversation with Mr. Seymour, whose memory seems to fail him with regard to the detail of that meeting?
And yes, yes, I can, Chair.
Thank you. Do you have any notes yourself from that period of time to which you could refer?
No.
No. Would PwC Australia hold notes that you would have made at that time?
I would expect so. My recollection of, and I conflate the two meetings of the 29th of August and then the one in 2020, was that Mr. Sayers called me and told me a number of things, and I think what I did was that I quickly recorded it in just a draft email verbatim. That's my best recollection. It's certainly my clearest recollection is that that's what I did in relation to the meeting in 2020, which was, just before we went and dealt with the board the next day, that I caught very quickly what he was saying, because he was at the time quite agitated about the extent of the issues that had been raised, as I recall it, by Mr. Herschel.
So agitated that perhaps it's disturbed Mr. Sayer's memory, but it is very helpful to have this testimony from you to indicate that there is an email, which I expect would be available to PwC Australia to locate and to provide to the committee. So we will request that document.
And Chair, it will not be pristine work. It will be a quick trying to catch what he was saying on the phone.
Ms Beattie, I would never consider you lacking in thoroughness. I'm sure that you've got to do things in a very fast way in some of these jobs, and absolutely understand that.
Right.
Thank you. Could I ask, just for the record, what was the date of your departure from PwC?
I retired as a partner at 31 August.
Which year?
2023.
Okay. And that is after that tumultuous period from when, actually in this room, I asked the question on February 15, and then the release of the documents, the 144 pages, happened on May the 2nd of 2023. Had you been planning your retirement for some period of time, or was the tumult of that period enough to make retirement look a lot better than what you were experiencing in your role as...
No, Chair, I had planned my retirement for some time. My thinking was that in the normal course, Mr Seymour would have ended his first term at 30 June 2024, and then he would either, with board approval, stay on for a further 2 years, or there would be a new election process that would take him for a further 4 years. I had no intention of continuing in my role from 2024 to 26, or certainly not to 2028. And so I thought that he needed, or whoever was to become the new CEO, needed a general counsel in place 6 months before what would be or the changeover or the continuation period in 30 June 2024. So I had said to Mr Gregory in 2022 and to Mr Seymour in either late 22 or 23 that I wished to retire as at 31 December 2023, so that they could have in place a new general counsel who would have settled into that role by the time of the next election process at 30 June 2024.
Thank you very much for that. In the period of time since you were last with us on the 2nd of August, have you had any communications from former colleagues at PwC Australia or PwC Global?
I've had no contact with anyone from PwC Global, other than, and I'm not even sure whether his role is still with PwC Global, other than an Australian firm partner who now does an IT-related role for Global, who was going to be out into Australia and wanted to have a cup of coffee as part of a normal catch-up. I have received messages from current PwC partners to which I did not respond. I have received messages... I did receive emails or messages from current PwC partners. I responded to one who was a member of my team and purely to ask how she was. I received messages...
Who was that person?
That was Ms Sally Moroney.
Yep.
And I received a number of messages from retired partners, and I did respond to those, but in the most general way, not in relation to my evidence. And I received a message from Mr Sayers, and Mr Sayers tried to call me, but I did not respond to his message or to his call.
Could you provide copies of the messages from Mr Sayers and from current partners and emails to the committee, please?
Certainly.
And any responses, as curt as they may have been. in the period between February 15 and your departure for retirement on the 31st of August 2023, there were a number of engagements between PwC Australia and PwC Global. I understand that there were quite a number of people who came to Australia to, well, let's call it a damage control. Is that a fair description?
They certainly came to Australia in the discharge of what they would see as their obligations, and they were their obligations under the PwC-IL regulations.
So the PwC-IL regulations, which is the agreement that you have, well, that PwC Australia had as a franchise of the PwC International, and PwC-IL, is that a short term for PwC International?
Yes, and it's effectively the rules by which the network operates.
Right, and clearly there was something not right about what was going on in Australia, so you were visited by senior members from PwC-IL. Mr Moritz came, didn't he?
I don't believe Mr Moritz came to Australia while I was at the firm. I don't recall Mr Moritz coming. Certainly Mr Oldfield was present. He came, the Global General Counsel, Ms Weiss, was present, and there were a number of other people who came from Global as well.
Can I ask you to take on notice to provide a list of the people who were there? Ms Weiss, is that how you say her name?
Yes.
Weiss, yeah, Ms Weiss. What is her role in PwC-IL?
Well, she is the Global General Counsel.
And how would you describe your professional relationship with Ms Weiss in your role as the Office of General Counsel, PwC Australia?
We had worked together for a number of years. I had worked with Ms Weiss for a number of years. I reported to her in relation to matters as they arose that could be significant for the firm or for the network. And there was a flow of information between us. We sat together on a network committee. We had worked together on matters. I had also been asked from time to time to assist in relation to matters in other network firms where there were some disputes, and so I had cause to report into Ms Weiss in relation to those as well.
Okay, so based on that, it sounds like it was a pretty regular and ongoing communication with Ms Weiss. So could you give me a sense of when you informed Ms Weiss about the matters that became known to PwC Australia with regard to the ATO, TPB, Foreign Investment Review Board?
I don't remember the Foreign Investment Review Board matter, but on the ATO there was regular reporting in to Ms Weiss about it, and because the privilege issues didn't only affect the Australian firm, they were also issues that went to clients of the US firm. There were, the fact that we were saying to clients, and there were often discussions with US clients about the fact that this wasn't a legal engagement, or there were issues as to privilege and the production that could or had to be or would be given to the ATO was quite a significant relationship issue. So Ms Weiss was aware of that, and there was engagement with these clients and with the US tax leadership who were responsible for dealing with them.
And did that go back to 2016? Were matters raised as early as 2016 with Ms.
I suspect... my recollection is that the issues as to privilege were raised in a very preliminary way in December 2016, but they became much more prominent during the course of 2017. So yes, there was regular interchange or exchange with Ms Weiss in relation to those matters, as there was by the Australian tax group with the affected network or the other network firm whose clients were affected by it.
And the confidentiality breaches with the Australian government, when was Ms Weiss advised of that?
I advised Ms Weiss of that matter shortly after receipt of the letter of the 8th of March.
Of 2021.
21, I'm sorry.
That's good. And in 2017 and 2018, were you raising any concerns with Ms Weiss about matters here in Australia? How well does she know what's going on here?
Ms Weiss was kept informed of the issues that were arising. Now, was I telling Ms Weiss about every email, every document? No, but she was certainly aware of the issues that the firm was facing.
Okay. And your communications with her would be in what form predominantly?
By telephone.
By telephone. Did you communicate with her by email?
Occasionally, perhaps, but very rarely.
Did you send formal letters or copies of letters to her for her consideration? She's a lawyer, so I'm sure she'd need to see the detail rather than just a conversation.
I don't recall. There was a reporting mechanism that the Australian firm had where, and I can't remember when the reporting mechanism came in, where the Australian firm, as did every other network firm, had an obligation to report any what was called a significant adverse matter. So there was a report that was provided about matters. It was high level, but it was certainly the point at which things were more formally identified in writing by the firm.
And did Miss Weiss? Sorry, I think I've been saying her name incorrectly in my mind.
Well, maybe I'm incorrect.
No, that's great. Miss Weiss, did she communicate with you her concerns and give you advice about how to manage this problem?
We would certainly discuss how a matter would be dealt with in the sense that I would say, this has occurred, we're dealing with it this way. You know, we would share views. We both had similar backgrounds. We had both been litigation partners in large firms. We could speak to each other easily, and we could speak to each other in quite a shorthand fashion because we could understand the issues. So she would listen, and at times she would offer views, yes.
And what was Miss Weiss's view about the matters as of February 15?
So February 15, 2023?
Yes. Sorry, I should put the year on the end as well. It's a saga.
Yeah, it has gone on for a long time. She was concerned about what had occurred, and she was concerned about how this would be dealt with, and she was concerned to understand what its impact might be upon the network as well.
So there was a concern for the brand, PwC, clearly.
Yes.
Yes. And she was so concerned that she came to Australia.
Ms Weiss yes, she would often, part of her role was when issues would arise within network firms, she or one of her team would go to the affected location and would work through to understand from a network perspective how it had been dealt with and how it might be dealt with, and that was part of her role.
And on this occasion, Ms Weiss came and she stayed for some extended period of time, didn't she?
Yes, I don't believe she came in February 23. My recollection is she may have come in April or May, but I don't remember, Chair.
Yeah, so it's around that time. Sorry, excuse me. Okay, she may have come at some point of time, but she was here for several weeks. Is that correct?
She came for weeks, and then she would go, and then she would come back again.
Okay, and during that period of time, did you seek her counsel, or was she giving you directions? Who was in charge at that point of time?
In charge in relation to the Australian firm?
Yes. Technically and practically.
At some point, and I can't remember when, a direction was given to the Australian firm that effectively meant that there had to be prior consultation with Global in relation to matters. So it was a supervisory role they had, or a direction to comply, and so there was a transition period, if you like, as Global became aware of all of the various matters, and as they got up to speed with many matters. We're not just talking about TPB. With many matters that they would be consulted, they would see draft letters, they would comment, they would drive strategy. And part to your earlier question about why I retired when I did, having planned a December retirement, was really I'd worked very hard in the period probably from April until late June in not only responding to what was going on and consulting with Global as required, and dealing with the various issues in you know, making sure that Global was across the issues they wished to understand. By the time we got to June and late June, it became clear to me that the firm needed the benefit of advice from one voice. It didn't need advice from me and advice from Global. You know, it was time to let those who had come in under the regulations, as they were entitled to do, to run and direct, rather than a process where drafts were being reviewed. And so it wasn't done it wasn't done petulantly by me. It was really the decision that it was in the best interests of the firm, now that Global was completely up to speed on almost anything that was relevant to their considerations, that they provide, you know, that they provide the ongoing role. And so I thought it was in the best interests of the firm that I speed my retirement, and frankly it was in my best interest too. There was nothing to be gained by different views, different perspectives. That doesn't mean one was wrong or one was right. There was just not the luxury of two different views or two different perspectives, as sometimes would occur, being dealt with.
So that's a very elegant answer, but it sounds like there was a takeover underway by International, that they came in, they were overseeing all of your work and others in preparation for what ultimately has been a formal takeover of PwC Australia by PwC IL. That sounds like what went on, Miss Beattie, that PwC Australia was a recalcitrant child, that the parents came in, said, we're not putting up with this anymore. You said they were there to drive strategy, which I have a whole lot of questions that I probably need to put on notice about that. And this was not apparent to the market. This was not known to people whom PwC were engaged with. This was all done quietly inside PwC, the plan for the takeover, and then formally there was a supervised remediation notice provided.
I wouldn't call it a takeover in the sense that there was still input, there was still an Australian governance board, there was still an executive board, but there was very much...
But that governance board had not even been able to deal with the concerns that you raised about Mr Seymour. That governance board has been the matter of some interest to Mr Switkowski. That governance board is the thing that PwC are saying now they're going to fix up, because it was wholly inadequate by putting three independent people on. Yet it seems to me, from what you've just described, the governance board is window dressing and the real power lies with PwC International.
I would say that PwC International was providing direction as to the firm's response to things. Takeover is a difficult word, because the machinery of the firm, the day-to-day, all of the things that would occur were still clients, work was being done by Australian partners, not by Global. It was that
they were being told what to do, given direction, is your words. I said takeover, you say given direction by PwC International.
But yes, but not on the day-to-day of tax partners doing a tax engagement. They had come in, there were certain areas of focus, and when we were dealing with regulators, if there were disputes, on governance issues. They were certainly giving consideration to how the firm would look going forward with Mr Burrows, Ms Stubbins. There were all sorts of governance issues being considered in circumstances where, Mr Seymour had gone and many members of the executive board had gone as well.
Did Australian staff members answer to Ms Weiss? Where did she place herself in the hierarchy?
Ms Weiss was not running the Australian firm in that sense, but if there was a staff member in my team, for example, that had drafted something that was considered of significance by Global, then Ms Weiss, or members of her team more particularly, and some of her members of her team came out to Australia, would look at drafts, would participate sometimes jointly in meetings. They had an involvement on those matters they considered of relevance.
Sounds like they were all over the place like a rash.
I don't know that I would describe it that way.
No, Miss Beattie, you're very careful with the words you choose. I'm trying to understand this as an Australian citizen who sort of has a sense of pre-WC Australia really being looked after here in Australia and having autonomy, and it's quite shocking to hear that, this plane load of people arrive with Miss Weiss, come in, and Australian staff are reporting to them. You're, with no disrespect, essentially displaced by Miss Weiss's arrival, and others you refer to. So who were the others who were, a part of this international presence in the period from February through to the date at which the supervised remediation correspondence was sent?
And maybe if I can just come back, I don't think I was displaced by Miss Weiss, but I was doing drafts of documents that were then considered by Miss Weiss and her team, and that's fine. Right? That's a part of the process, but I wasn't displaced in that sense. But the firm needed the benefit of one.
Yeah, and I don't mean it as a personal slight to you at all,
No.
Miss Beattie, but clearly it was a very, very different way of doing business from the way you had operated until the arrival of Miss Weiss,
Yes. Yes.
in 2023.
Yes, it was a different way of operating, and it was driven by concern. And they had the power. PWCIL had the power to come in under the regulations and give the direction that they gave as a way of looking into things and being satisfied as to network issues and the brand.
The ATO, TPB, Chartered Accountants Australia and New Zealand are still interacting with PwC Australia, but at the same time as they're interacting with you through 2023, essentially we've got an international team making decisions. That is of concern to me.
Well, they're making decisions in the sense that if we were going to, let's say we went to speak to CANS at various stages about the issues and to brief them on what was happening during 2023, and I went with Mr O'Malley, who was the then ethics leader, and we would certainly tell Miss Weiss or members of her team what we were going to do, what we were going to say. If she had any input into it, she would provide that input. So they were briefed, and it was a...
And she was there much more than Mr Moretz, based on your evidence.
Oh, absolutely.
Mr Moretz came later, so she's really the driver of the response to the committee's concerns that were raised between February 2023 and now.
I think there were probably a lot of people, not just Miss Weiss. There was Mr Oldfield.
Yes, you've mentioned him.
He was very... My sense was he was very actively engaged in the response, how the firm, their matters would all be run through Mr Oldfield concerning the media, the responses, how it might be dealt with. He was actively engaged. So it certainly wasn't Ms Weiss's Global General Counsel running the Australian firm. There were many people who were involved, and they were also there to work with the Australian firm. I mean, it was a time of great turmoil, and I know that on the last occasion...
We know, because we were here.
No.
And it concerns me that Mr Oldfield was here to run media because during that period of time, requests for information from PwC and clarity and communication about exactly who had done what was absolutely not forthcoming. So it concerns me that, you know, we might have now have the name of the person who was responsible for what the committee's described as, this committee and the F&PA committee have described as serious interference with our work. Is Mr Oldfield the one responsible for that, not Ms Weiss?
No, look, Chair, I don't know all of the information that you're referring to that say there was serious interference. I can say, for my own role, that there were many, many discussions about how you manage the disclosure, manage in an appropriate way, the disclosure of information to the committee, the issues with confidentiality attaching to the TPB matter. There were many issues discussed. It wasn't I did not see any evidence of either the Australian firm or the Australian firm working with the global firm withholding information in an inappropriate way. I did not see that. Now, I don't know what you've seen. I can't comment on that. I can only tell you from my own perspective.
I think the committee's concerns are a matter of public record. They are in reports, and we continue to be concerned about the failure to respond to requests for documentation. And, you know, we had to go through the processes that Senator Scarr described earlier this morning to engage you, Ms Beattie, because, and you have honoured your responsibilities as an Australian citizen and acted in accordance with the sort of standards that be expected of lawyers, responding to the request of the Senate, understanding that, you know, we have a right to call any person from any walk of life. Being in a big business and on a big salary doesn't, put you above and beyond the law, and that the Senate's role and the House of Representatives too is to make sure that we investigate things in the national interest. And the driver for me in all this has been how vital PwC, as a fundamental truth-telling entity in the middle of our financial services sector, needs to be operating at an ethical level that maintains the integrity of our system for all Australians who have an interest in how markets work through our superannuation. So that is my motivation for doing this work and for holding PwC to account. And I thank you for your testimony. It's been quite helpful this morning. But we do have a different view about how forthcoming PwC was. Can I go to the fact that in March, just to illustrate the obfuscation of the work of this committee, in March this committee requested PwC Australia provide copies of the supervised remediation correspondence between PwC Global and PW Australia, which was in response significantly to the PwC tax leak scandal. As of now, it has not yet been provided to the committee. Are you familiar with this correspondence, Ms Beattie?
Sorry, Chair, could you just read that to me again?
The supervised remediation correspondence between PwC Global and PwC Australia, were you involved in its preparation? Were you involved, did you receive it? What's the timing on that?
My best recollection is that there was a direction that came from PwC-IL, or it may have been the Global Board, about the role that PwC-IL would play as a result of the issues that had arisen. So that there is a document that sets it out.
Can you outline from your memory what conditions PwC Global placed on PwC Australia in the correspondence?
Not with any degree of precision. It was to the effect that there would be a reporting in and consultation with PwC-IL on certain matters, and I can't remember exactly the certain matters, but that was the nature of the direction as I recall it.
And were there consequences foreshadowed if compliance with the direction was not met?
I believe so. I think I believe, and this is the vaguest of recollections, there may have been something, or maybe I knew it from the regulations, that if there was non-compliance, there was potential for the firm to cease to be part of the network.
Okay, so I'm sure that that's quite a shocking thing for the public to become aware of, that the document was a trigger for potential dissolution of PwC Australia.
If there was non-compliance with the request.
Okay, and non-compliance with the request of PwC International.
It may have been the global board. I can't remember the formulation of it. You actually probably need to see the direction, Chair.
Well, we do actually, and we have been asking for it for several months, but it has not yet been forthcoming. And perhaps it's because PwC Australia and PwC International don't want clients to know that there is a group of people in New York who have PwC absolutely in their grasp and are saying, if you don't do it our way, and if you don't provide information to us, through us, get it checked by us, we will just dissolve PwC Australia. That is a great concern to me.
I think, Chair, and I don't want to be in dispute with you, but I think it is rarely ever triggered, this situation. As far as I know, it is rare for PwCIL to issue a notice of this kind, and it is only in circumstances where it feels there is a matter of great significance that it must do this, and I can't speak for Ms Weiss about this, but certainly I imagine that one of the issues that was relevant, and it certainly was something that I observed at the time, was that the firm had lost its CEO, a number of its executive board members. There was we were trying very quickly to fill the void, but it was a void. There were issues, there was media, there were very significant matters, and they felt that was sufficient, or the global board felt that was sufficient. It would have been the network leadership team, I believe, felt that was sufficient to issue the direction. So it wasn't, and I suspect, but I don't know, that the very same rules and regulations exist in relation to other network firms. So other firms that are part of a network, that there is a point at which people from a global vehicle of some kind or a network leadership team can come in and have a role for a period.
And that was what was happening?
Yes.
So can I go to Mr Burrows?
Yes.
When did Mr Burrows first come to Australia to assist with this matter?
I don't recall. I suspect it may have been April.
So there is some public perception that Mr Burrows came in, appointed by Global to take over from Kristen Stubbins, and that was his first engagement. But that's not correct.
No.
Mr Burrows has a role on Global. Why was he brought into Australia in April, and did he come with Miss Weiss?
No, I believe he was nominated by Global as a person to come in and assist as a senior person, and he certainly had a role long before his appointment to replace, or when I say long, I can't remember actually how long. But
in the months preceding?
Yes, in the months preceding his taking over the role from Ms Stubbins, he had a role for Global within the Australian firm, and was very actively engaged in looking at the firm's responses. And I would say his role was to be, from my observation, was to be the person on the ground on a day-to-day basis for Global before he took over Ms Stubbins' role.
Okay, so in a way, it would appear to me that when Miss Weiss arrived, Mr Burrows either followed very shortly afterwards or was there around at the same time. And he was actually, from his arrival in Australia, being prepared for the ultimate takeover that was triggered formally by the supervised remediation correspondence. So Mr Burrows was in on the ground.
I think the direction that I referred to, I think I think, came before Mr. Burrows came in. He sort of came in as a consequence of that, I think, but you know, my recollection is very vague.
I don't believe the remediation was later.
No. Well, there was a direction given in I don't recall. It may have been May. It may have been April. That went to the role that PwCIL would have, or the sort of supervision, if you like, or the role that it would have with the Australian firm.
Right, because May the 2nd was the day that the TPB documents, the 144 pages, were released to the public. So it was around that time that Mr. Burrows came to Australia, is that correct?
He may have been there before.
He may have been there before, yeah, in anticipation of what was about to happen, perhaps.
And I think he may have been there before, yes.
So Mr. Burrows was being paid at that period of time in his role as global. He was then appointed by virtue of the remediation correspondence, the remediation, supervised remediation letter.
I don't know. I don't remember. I thought Mr. Burrows came in at some point as replacement for Ms. Stubbins, and then later his period was extended. That's my recollection.
Okay, but he was here before all of that?
Yes, he was.
He was. So Mr. Burrows is a constant from global, remains in Australia. He came to the Parliament, and when I asked him what his salary was, this is now also a matter of public record, he said 2.4 million, corrected it within days to say it was actually 2.8 million, but did not disclose to the Senate nor to his partners, his Australian partners, with whom he is technically jointly liable because of the partnership rules that under which it operates. He did not disclose to them the $1.2 million plus bonus that he's receiving from PwC International. Ms. Beattie, as an Australian, does that concern you, that there is that level of obfuscation, that level of failure to provide in a transparent way, not only to the Senate, but to his own partners, of which there are like 900, a few less now. Mm. But does that disclose you? Does that disturb you, that there's a failure of disclosure of that level to the partners of PwC Australia by the person who has been imposed on them as their leader?
I think I would want to understand why Global was paying an additional amount to Mr. Burrows, whether it was doing it because Mr. Seymour had received a certain amount and so Global was topping up, if you like, the amount he was receiving, because the amount Mr. Burrows would otherwise receive would have been significantly less because of profitability issues than Mr. Seymour would have received. I would have to understand why he was being paid the additional amount.
Yes, I'm sure that you'd struggle to understand it, and you were in there. To me, it's completely inexplicable. And the committee's indicated that we do consider it a conflict of interest, that Mr. Burrows, whether it's a top-up or a payment for particular services as a service agreement that he has said is another job that he has, essentially, with PwC. Ms. Beattie, does it strike you that this is a conflict of interest, that Mr. Burrows is supposedly leading the Australian partnership team, has failed to reveal his additional payment from PwC International, and is doing work on a contract with PwC International, which, and we've asked for that documentation, and that still has not yet been provided. That appears to the committee to be a conflict of interest.
I don't know whether it's a conflict of interest without understanding what he's doing for Global. Certainly, as a partner of the Australian firm, he has to act in the best interests of the Australian firm. He has obligations, and he owes obligations to his partners, his Australian firm partners.
So the first obligation is to be frank, open and honest. Mr Burrows revealed his $1.2 million to a small group, that governance committee, which is always touted as the vehicle that's going to lead to a great outcome for people who use PwC Australia, that the governance is in order. Yet he revealed his $1.2 million from Global to that small group of people who kept it to themselves. They didn't tell their other partners. Nobody knew about the 1.2 until we sent a request asking for clarification if he received any money from PwC Global. Only when he was found out, Mr Burrows then determined to call a meeting on the Friday before his question on notice was due, on the Monday. He called a meeting on the Friday and coughed up the information. All 1.2 million became known to the partners on that day. According to evidence from Ms McKay, who is the risk manager, she did not even know. Now, Ms McKay has a very important role right now. She's been directed by the TPB to declare on a 6-month basis conflicts of interest. But you can only declare a conflict of interest if you actually have an ethical muscle to discern it and an adequate process to capture it. How inappropriate then is it, Ms Beattie, that Ms McKay was kept in the dark, the Chief Risk Officer for PwC, after all this disaster, imposed and sanctioned, put into the role and sanctioned by PwC International, was kept in the dark by Mr Burrows, her governance board and PwC International about the 1.2 million plus bonus that the CEO of PwC Australia was receiving?
I think if I were Mr Burrows, I would very much regret that I hadn't shared with my Australian firm partners what was occurring.
Would he have been directed to keep it silent by Ms Weiss?
I suspect that is unlikely. I don't know, and I shouldn't speculate. But I think for Mr Burrows, the important thing for him is to lead the firm forward and build the confidence and respect from the Australian firm so that it can go forward in a successful way. And so for me, and I'm not Mr Burrows, I would regret that I had not made that information available sooner.
So that was a very clear indication that that you perceive, like me, a failure in this regard, that you would have taken a different direction.
I would, if I were Mr Burrows, I would have shared all of that information with Australian firm partners because I would want to make sure that I had their support and that they were, their confidence and that they were aware of what was happening. So I would have shared it. I don't know what direction, if any direction, was given to Mr Burrows or why he did or didn't choose to share it sooner than he otherwise did.
He only shared it when he was compelled to do so because of the work of this Parliament.
Certainly the timing suggests that's the case, yes.
What do you believe Mr Burrows' action reveals about the authority of the Australian risk management senior person, which is Ms McKay, who's had, an extraordinary career and worked in compliance, understands Australian law? What possible explanation could there be for the PwC International imposed CEO for keeping a conflict of interest, or at the very least, a very seriously perceived conflict of interest from his own risk officer who was reporting to the Australian TPB on a regular basis?
I can't say, because I don't know the facts, whether it is or isn't a conflict of interest. But I would expect that as the firm goes through this phase, it is working out the information that needs to be shared. And yes, I'm sure if Mrs McKay was here, she would say that she would have expected to have been told that.
You indicated in your earlier response that Ms Weiss and others at PwC International receive regular reports on what is happening.
Yes.
The reports that Ms McKay is sending to the Australian regulator, the TPB, were inadequate in that they did not declare Mr Burrows' salary and the conflict of interest there. Would those documents be sanctioned by PwC International? Is there a requirement for them to reveal what they're doing to PwC International? It looks like they're everywhere. So
I don't know the extent. I don't know the extent to which that sort of information at that level of detail would be shared with Ms Weiss. It may be shared with members of her team, because the reporting obligation was one that came out as a sanction from the TPB matter. So I would expect that members of Ms Weiss's team would see the response, because it's an important response. I suspect, but I don't know, that Global and maybe the Australian firm takes the view that it is not a conflict of interest. I don't know, Chair. I can't help you with that. If
no, but it's been helpful to indicate that you acknowledge that the TPB matter is an important matter. Yes. That the reporting requirements imposed on Australia and maintained by Mr Burrows require that information that's provided to Australian regulators has to go through a clearance process from PwC International.
I assume, because of the significance of the reporting and the necessity for compliance with the sanctions outcome from the hearing, that it would be something on which there would be consultation with Global.
And in that instance, it is impossible that PwC Global did not know that the person they were paying $1.2 million to wasn't given consideration in terms of its reporting.
I can't say it's impossible, and I haven't been at the firm for 12 months,
yep.
but I would say to you that my expectation would be, as I knew matters from 2023, that it is something on which someone from Global would have had some consultation.
Thank you. I just might move to a couple of discrete matters. When you left PwC, you've indicated you have documents that you've created yourself. You were given access to some documents. How were you provided with access to those documents in preparation for your appearance here on the 2nd of August?
They were provided to me by the firm's lawyers.
In hard copy or email?
I think some were hard copy, some, as you heard from the last occasion, I had some lawyers assisting me in compiling information, so it may have been provided to them, but certainly it was some information that came from the firm's lawyers.
So what documents were you provided with, and having received them, I'm assuming you continue to have access to them?
Yes, I continue to have access to them. They were documents relevant to the ATO matter, the professional privilege issue and the TPB matter.
Could you provide those to the committee, please?
Certainly.
Thank you. What role just for total clarification here, what role did the Global General Counsel, Diana Weiss, play in response to the tax leaks scandal? Did she have a particular role?
At which point in time? Throughout?
Yes, and did that change given the nature of your response then?
Ms Weiss was made aware of the matter, as I mentioned, shortly after the firm was served with the letter of 8 March 2021. And thereafter, from time to time, there would be reports, in the sense that I would telephone Ms Weiss, and when I was talking about matters, I would mention the TPB matter and other matters that were arising, whether in tax or other things. So she was kept up to date, and she was made aware of the outcome of the TPB matter once it was received. So there was a regular reporting to her in relation to the TPB matter, as there was concerning other matters that the firm was facing.
you've described the nature of your interactions with her. Could I ask you to describe the nature of the interactions of Kristen Stubbins, who... Well, let's just go back to Tom Seymour. So what were her interactions with Mr Seymour?
While Ms Weiss will have met and Mr Seymour from time to time, he did not report to her or engage with her.
And did she arrive before or after his separation as the CEO? I don't recall Ms Weiss engaging with Mr Seymour, so that makes me think that he may have gone on leave, or, you know, his arrangement may have come to an end at around that time. I don't remember there being a level of engagement or any engagement between Ms Weiss and Mr Seymour when she arrived in Australia. I could be wrong about that, but I don't remember it. Okay, who gave Mr Seymour the shove, if I can put it that way?
Mr Seymour decided that he should go and had discussions with the... I believe, I don't know, I wasn't party to them, with his executive board, and it was also went before the governance board as well.
So was Mr Seymour called to the executive board to give an explanation, and the same to the governance board, or did he just volunteer himself sacrificially? How did that process unfold?
I believe he volunteered himself sacrificially, to use your phrase.
Okay. And in his preparation for that moment, whose counsel did he seek? Did he discuss his situation with you?
In making that decision, no, he did not.
Okay. In what way did you engage then with Mr Seymour in the lead up to his decision to terminate himself and step away from PwC?
I had a discussion with him, I think it was on a Saturday or a Sunday, maybe a Saturday, as the media reporting was coming in and issues were arising in a very public way, and I said to him, I posed as a question whether this was something he could withstand.
Okay, so would you say it's fair to say that you were encouraging him, or were you genuinely just seeking a register of his personal state?
I think there were the two aspects to the call. I was certainly acutely conscious that he was under enormous pressure, so it was a call into him, you know, how are you? Are you
Yes.
okay? And the second thing was, do you think you can withstand that? And I think at the time he may have been speaking to people in Global, not Ms Weiss, about it, but having discussions with others.
Who else in Global? Not Miss Weiss, you say Mr...
No.
She stayed away from that bit.
She and Mr Seymour were operated in different spheres. I mean, Mr Seymour was...
Miss Weiss was always talking to you. Mr Seymour was speaking to whom?
I think I think he may have been speaking to Mr Ryan, Mr Tim Ryan.
Who is?
I think at the time he was the CEO of the US firm, and he was certainly a member of the network leadership team.
And what is your knowledge of those communications between Mr Tim Ryan? You know that they occurred, so did Mr Ryan say, look, I've had a talk with him, I think it's time for him to go?
I don't know. Mr Seymour did not tell me he had been talking to Mr Ryan, I don't think.
So how do you know about it?
I don't know. I can't remember. He may have told me, or I may have heard it from others at some point.
From Miss Weiss?
No, well, I don't think so.
Sounds like there's a lot of chatter going on at that top level about, you know, managing the media by the sounds of things.
Well, it's not so much managing the media, but this was, and I know you know this, it was such a significant time that your CEO is going to step down, And the CEO, as you know, had such extensive powers under the partnership agreement that it was, how is this going to be managed? And so I imagine, but I don't know, that Mr. Seymour was seeking some guidance from Mr. Ryan in relation to it.
Okay. The CEO, of the time, Mr. Seymour, steps aside. Was there any correspondence or any communications between you or Ms. Weiss and Mr. Sayers, who was the CEO when all this matter unfolded?
No.
Was he ever consulted in the middle of this process?
No, not to my knowledge.
Okay. In terms of the replacement of Mr. Seymour with Ms. Stubbins, were you a part of that process?
Yes,
How did that occur?
The decision was taken over the weekend, and I can't remember the weekend, which weekend it was, that Mr. Seymour would stand to the side, and then I believe there were discussions possibly within the executive board and the governance board about...
Of the Australian one?
Of the Australian firm, yes, about who the replacement might be. I was a party to some discussions about who the replacement might be, and ultimately Ms. Stubbins became the person that went forward on the basis of consideration, I believe, by the governance board.
So there was no vote, there was no sort of popularity contest, which is the way in which Mr. Seymour and Mr. Sayers were elected.
No, it was an interim. There is a provision, I think, in the partnership agreement that allowed an interim person to go in for a period, and so it was effectively putting in a replacement for an interim period. It may have been 3 months, I can't remember, and then there might have been an election, but we looked at the ability to put someone in place of Mr. Seymour.
And was it unanimously agreed by the governance board, you said, that Ms. Stubbins was the right person for this role?
There was a lot of discussion about who it might be, and I think at one stage the governance board was thinking it may be another member of the executive board, but ultimately the governance board came to the view that it would be Ms. Stubbins.
So Ms. Stubbins took on the role in good faith, and but by this time, PwC Global are all over the joint. They're swarming around Australia. Did Ms. Stubbins have to report immediately to the global board prior to the actual formal supervised remediation correspondence?
I struggle because I don't know what the supervised remediation correspondence is, but
hopefully you and I will both see it, Ms. Beattie.
Pardon?
Hopefully you and I will both see it sometime soon if PwC Australia complies with its requirements under the Australian law.
Certainly, under the direction that was given that I'd referred to earlier, Ms. Stubbins was obliged to consult with Global on certain matters. Yes, I was obliged really to consult with Global, yes.
So, if I can put it this way, the interim CEO, Ms. Stubbins, became the face of the Australian partners, but the real power at that point of time actually lay with PwC Global, who were overseeing her work and observing documentation, approving release of information or withholding of information from the Senate?
Let me try and respond to that. I think Ms. Stubbins would say, justifiably, that she was taking decisions, and then she would, she was forming a view about the way she would deal with things and how she would deal with it, and then she would check in or consult or inform Global, because there was very much a working together. It wasn't that she was purely and simply directed what to do, and then in some sort of puppet-like way she did it. She was...
Yeah, I think, having met her here, that she has her own standing and her own integrity, but she certainly left under a cloud and was not happy in being dismissed from the role, and had some recollections of, you know, a degree of autonomy being removed from her because of the way in which PwC Global were operating prior to activating the supervised remediation.
I think there was a sense of enormous pressure for Ms Stubbins in that there were things that she wanted to do and wanted to do in a particular way. The matter was the whole process, everything that was occurring was very fast moving, so consultation was difficult. There was always going to be a tension, I think, between someone in the CEO role and an oversight function, and it was just how you managed that, I think.
And you described your management of it, which was to step aside.
My management...
A little earlier than you planned to retire.
Yes, but it was because I was not... the decisions, the firm needed advice being given by one voice, and I suspect Ms Stubbins' frustration was that she was sitting there in that role, and while she was obliged to consult and work with Global, I think she probably found that challenging from time to time in the
circumstances. So who really runs PwC Australia, given that partners aren't informed by their CEO, given that there's all this correspondence going backwards and forwards, given that Ms Weiss is telling people what to do? Who really runs PwC Australia?
I don't know now who runs PwC Australia. I assume it's Mr Burrows and PwC Australia itself. But I think in that interim period where the firm had lost its CEO and many of its senior members, that certainly there was a need to work with Global to get through the immediate process.
Thank you for your answer. Can I go to some clarification around the internal processes to determine which members of the Australian firm would be named and face the consequences as a result of the tax leak scandal, because that was the frame in which these people were named. Ultimately 9 people: Richard Gregg, Peter Konadaris, Eddie Musa, Pete Kalaja, Sean Gregory, Wayne Plummer, Tom Seymour and Peter Van Dongen were exited on, well, in a public place at least, the basis of involvement with the tax leak scandal. Is that correct? Were they all released on the basis of their connection to the tax leaks scandal?
I didn't make the decision about the release. That was not made.
Did you prepare documentation for others to consider in their calculations of who would be named and the names that were given to the media and the Senate?
I certainly provided, and if this were to be discussed, I would need to do this in camera. I provided advice about the selection process or which partners may or may not be exited. But ultimately the decision, I was not involved in the decision that was taken.
Who was responsible for the decision?
The governance board working with Ms Stubbins.
But we know that the governance board working with Ms Stubbins were being supervised.
Certainly, yes. There was the involvement of Mr Burrows at that point in time, and Global were also involved, yes.
So it wasn't a decision made in Australia, it was a decision made by Australians, but with the supervision already in place, informally and then later formally, involving Mr Burrows?
I think I think it was part of the formal by that stage, in the sense that I believe by the time I think the decision for their exit came about in around 2 July or 3 July 2023. And that decision was made by the governance board and Ms Stubbins after consultation with Global, and that consultation included Mr Burrows.
Did it involve Ms Weiss?
Yes, it did.
Did it involve other people that you've mentioned today? Did it involve Mr Moretz?
I don't know.
Mr Oldfield?
I can't recall whether Mr Oldfield was retiring, And so I can't remember.
He was the one who was managing the media, though, so he would have been involved in figuring out who was going to be released.
He retired. He may have been involved. I can't remember.
Can you take that on notice and give a full answer to what role did Global General Counsel Diana Weiss have in determining the accountability for the tax leaks scandal? I'm going to ask one more question on the record. On page 35 of the transcript from your previous hearing, you stated, "I did not have any involvement in the response that was given concerning that. I was aware that I believe the words were in 2019, Mr Collins had shared information in Ireland. That was what I understand, was said by Mr Hershorn to Mr Sayers. That's my recollection. I understand there was a response to that probably by either Mr Seymour or Mr Plummer to the effect that he didn't breach confidentiality because there wasn't a confidentiality agreement in place." This is a point on which people have very different accounts. Yes. Do you have any documentation to support your version of the events?
I have a message. The context that I read to you, or read to the Senator Scarr, it comes from a text message I have from Mr Seymour.
Yes, so could you provide that to
Certainly.
the committee? Thank you. And any other documentation that would exist to support one narrative over another, whether that's emails, contemporaneous notes, reports, and if there are documents that you no longer have access to that are held or should be held by PwC in accordance with standard governance practices and, proper standards for Australian businesses, could you identify any documents that may assist the committee? I'm going to seek from my colleagues the opportunity to go in camera for a short period of time to provide you with the opportunity to give us further information about the way in which the determination to release 9 people occurred. Thank you. Yep, so we might need to let our next witnesses go or silence them in some way. So the committee will suspend the public hearing at this point and move to a short in-camera session with Ms Beattie. Thank you. Perhaps you can't hear us at all.
So it looks like none of the witnesses are hearing us. Do you just want to go into the broadcasting?
The committee will suspend until we clarify our line of communication with the witnesses from the Law Council.
Yeah, it doesn't look like they're hearing us.
Perhaps you didn't hear the first part. So the committee will resume. I now welcome the Law Council of Australia. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear? And we'll start with you, Ms Warner.
Juliana Rose Warner. I am President-elect of the Law Council of Australia.
Mr Stevens.
Stephen Stevens. I'm appearing in my capacity as Chair of the Professional Ethics Committee of the Law Council.
Mr O'Loughlin.
Frank O'Loughlin, a member of the Business Law section of the Law Council Tax Committee, and I'm a barrister.
Thank you. Miss Campbell.
Jenny Campbell, General Manager Policy, Law Council of Australia.
And Mr Hawkins.
Murray Hawkins, Principal Advisor Regulation and Professional Standards of the Law Council of Australia.
Thank you very much indeed. And can I indicate the committee's appreciation of your tolerance over the time disturbance? We were in a position to take evidence from Ms Beattie in camera, and we didn't want to miss that opportunity. That will necessarily truncate our time with you, and there may be questions on notice, and there may be materials that you discern after our inquiries that you want to provide the committee with at a later date, and we would certainly welcome that. So thank you for your perseverance, thank you for your attendance today. I now invite you to make a short opening statement, and of course we will have questions.
I will make the opening statement on behalf of Law Council. First, of course, we acknowledge the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respects to elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples who may be present today. From the number of us present, we trust that the committee understands that Law Council has readily accepted your invitation to attend. If it's acceptable to the committee, I would like to make some short remarks because we haven't made a previous submission to this committee which is looking at audit and consulting services. But we are conscious that during the course of this inquiry process there have been discussions, amongst other things, relating to the regulation of the legal profession and the role and function of client legal privilege. We are, of course, vested in ensuring that the doctrine of legal professional privilege is properly understood. It is a fundamental common law immunity developed by the judicial arm of government and in many respects entrenched by the legislative arm of government. It preserves the confidentiality of communications, the seeking and obtaining of legal advice between clients and their lawyers. This immunity, which belongs to the client, not the lawyer, recognises that administration of the law and the system of administration of justice is a combined function of the courts and the legal profession. The receipt of unfettered and comprehensive legal advice advances the rule of law because it assists clients in conducting their personal and business affairs within the law. The immunity is there to ensure that the public can go to their lawyer and provide frank and full disclosure in a secure setting to obtain the legal advice that they need. The doctrine has been developed as part of a balancing exercise about what is in the public interest, and the balance has been struck in favour of preserving and protecting the security of the communication setting and thus the privileged information, rather than in full public disclosure. In the absence of that setting, individuals may be dissuaded from seeking the advice or being candid in communications in the process of getting that advice. But the immunity does not protect a communication that is made in furtherance of a fraud or a crime or for some other improper purpose. We hold the firm view that it is both the government's and the community's interests to achieve the dual goals of preserving the confidentialities that legal professional privilege claimants are entitled to preserve and providing regulators with the documents to which they are entitled. It also has to be recognised that legal practitioners have professional obligations to protect the confidentiality of their clients' information, including privileged communications, from disclosure except in certain limited circumstances. We think it's important not to confuse the effect of a claim for privilege which is properly made, but which may result in perceptions of impeding certain regulatory activities with motives for making those claims. And it's also important not to impugn an improper motive to those making a proper claim for privilege. The assessment of whether or not a communication is in fact the subject of legal professional privilege can sometimes be difficult to determine, and reasonable minds can differ on whether particular communications are privileged or not. But where there's any contention arising between an individual or an organisation and a regulator about client legal privilege should always be respected, and the courts should be the ultimate decision maker in that regard. Nevertheless, we are troubled by allegations of intentional misuse of client legal claims, privilege claims by some practitioners in order to frustrate or obstruct Commonwealth investigations. Well, obviously, we can't comment on any individual case. Our general response is that any attempt to misuse or deceive through improper claims is clearly not lawful and not something that a lawyer could legitimately contemplate. This would be outside of the bounds of professional conduct. It's important that existing legal profession regulatory processes, which in our view are fit for purpose, are used where they are appropriate. And that's why we have supported the introduction of reforms to remove secrecy restrictions that had previously prevented the ATO and the Tax Practitioners Board from raising disciplinary-related concerns about legal practitioners with the appropriate authorities. Under the reforms, these agencies will be able to raise concerns directly with state and territory legal profession regulators and have them dealt with under the comprehensive legal profession complaints and disciplinary arrangements that exist. We've also welcomed the Australian Government's announcement that it is conducting a formal review of the use of client legal privilege in Commonwealth investigations. Since this announcement, the Law Council has been working collaboratively with the Attorney-General's Department and Treasury to ensure that the forthcoming review is both constructive and well-informed. We have encouraged departmental officials to ensure that any responses adopted have regard to existing regulatory processes and, of course, are proportionate to the evidence about the nature and scale of any problems identified. We think it's important to highlight that the legal profession is, in fact, one of the most extensively regulated professions in Australia. That is the case for all lawyers, and whether they are practicing in a traditional law firm or a multidisciplinary practice or within a public institution. There are unique features about lawyers and the work that we do, which makes them, us, and the way in which we are regulated different from other professional service providers. For example, it is important to recognise that the paramount duty every lawyer owes to the court and the administration of justice, through which lawyers underpin the third arm of government, which is the judiciary. It's also worth noting the foundation of the lawyer-client relationship in fiduciary principles, such as the duty of undivided loyalty and the centrality of trust and confidence between client and lawyer, which, in combination with the duty to the court and the administration of justice, compels exemplary ethics and standards of professional responsibility. While the regulation of the legal profession occurs at the state and territory level, the Law Council is a major participant and contributor to shaping the legal regulation through its work on the Legal Profession Acts and the Legal Profession Uniform Law Scheme, and through its advocacy on federal proposals that affect the legal profession. In addition to its work on the primary legal profession regulatory laws and policies, the Law Council also developed the Australian Solicitors' Conduct Rules, which are a single set of professional conduct rules which govern all of Australia's solicitors. We'd be really happy to discuss how these regulatory frameworks operate in detail if it would assist this inquiry. thank you for the opportunity to appear today, and the Law Council is very pleased to respond to any questions that the committee might have.
Well, thank you very much indeed, Ms Warner, for that very important statement. Can I just indicate that one of the concerns that the committee has is an apparent misunderstanding of the powers of the Senate to compel documents, which appears to be in contest in some cases, not just for entities just like the ATO, but for the Senate in terms of acquiring information that is being withheld under the claim of legal professional privilege. There are jurisdictional boundaries. We can't go beyond Australia. This committee, I think you would know, has been seeking a report undertaken by Allen's Linklaters internationally, and any advice you can give about the international family of lawyers that might help us with that problem would be very, very welcomed. As I indicated, we are going to be truncated. I'll go to a couple of questions now. The first one is, the committee is interested in the concept of public interest entities. Could you explain what public interest entities are and the implications of that designation?
Stephen, I might throw that one to you.
Thanks, Juliana. I'm not sure of the term public interest entities.
We may send you that one on notice then, because I don't want to put anybody on the spot.
Is there any particular body you're referring to, Chair?
Well, in its supplementary submission 43, PwC proposes a mandatory Australian public interest firm governance code, and that's one of the solutions to trying to improve the governance standards. But it's also been put to us that a public interest entity could be the way in which these large companies might need to be declared, so there's a greater degree of scrutiny. So I'll put that question on notice to you in some detail.
Thank you.
Can I ask if you have views on the options with regard to these large companies? PwC, KPMG, Deloitte and EY all operate partnership models which reflect a very, very different understanding of partnership from the days before the change of status under Mr Howard, when 20 was the maximum number of partners, and it's led to quite significant changes. Now partnerships up to 1,000, and that's what we saw these entities get to. There's been some discussion about the separation of these entities who have, as you noted, multidisciplinary teams, including lawyers embedded in them. Have you given any thoughts to the status quo, operational separation or structural separation for addressing the conflicts of interest that arise when firms provide both audit and other consulting services to the same client, including legal services?
Murray, could I suggest that you have first go at that one?
Certainly. Thank you, Senator. Multidisciplinary law practices came about beginning in the late 1980s as part of the national competition policy reforms process that went on until the early 2000s and resulted in the national legal profession and national regulatory framework, national legal services market that we have today. The impetus for them in the first place was that there was connections between provision of legal services and other legal services as not part of business activities. The Law Council supported the ability of law practices to use alternative business structures and provide legal and non-legal services, but with three essential qualifications. The first one was that whatever business structure a law practice provided services under must always maintain professional standards and obligations of legal practitioners and not diminish in any way from ensuring they're delivered. The second principle was that regardless of whichever business structure is used, the rights and remedies available to consumers should always be preserved and protected. And third principle was that adoption of an alternative business structure needed to be in the public interest. The way those principles, particularly the first two, are currently addressed in the legal professional laws of the states and territories, particularly features in current law that legal practitioners and law practices must comply with the regulatory laws regardless of the business structure in which or in connection with which the legal services are provided. Each principle is responsible for ensuring reasonable steps are taken to ensure the practice and the legal practitioner associates comply with their obligations. There's a extension of liability for principles and law practices for contraventions, and legal practitioners, regardless of the capacity in which they are engaged or employed in a multidisciplinary type arrangement, don't lose their professional privileges or their requirements to meet their professional obligations. There's also protection built in to the existing legal profession laws that a person must not cause or induce or attempt to cause or induce a law practice to contravene the legal professional laws of their professional obligations. So we are at a point where we have a set of principles that the Law Council believes are the ones that should govern multidisciplinary law practices. We have provisions written into the legal professional laws that give effect to those. Where I think we are at now is at a point where we're seeing a point of evolution in multidisciplinary partnerships and the provision of legal services within that. We're at a point where, particularly coming out of this inquiry, we'll have a need to have another look, a deeper look at how things have changed. And it's all against the background of the Law Council's fundamental view that we have to maintain the integrity of the profession, the integrity of the administration of justice, and whatever business structure is used shouldn't impact on those principles.
And I would just jump in there to add that the obligations on the lawyers in such, in alternative business structures is to ensure that they do comply with their professional obligations, and there are also offences for people who try and exert pressure on them not to do so.
And how
it's
many
a breach of the uniform law.
Yep. So I appreciate that very clear testimony, Ms. Warner. So how many cases have been brought, and what are the outcomes of those cases against the coercive practices that I think have been demonstrated in the evidence we've received, particularly around the use of LPP, where basically it was wave your magic internally employed lawyer over these documents, and not in accordance with the requirements that were made clear by Ms Beattie in her evidence to this committee, but in accordance with the business incentive, make inappropriate claims against the Australian people to the ATO of the term legal professional privilege over documents that were tax documents, not legal documents. Who's been held to account for that? And what courts? And what are the outcomes of those who persuaded lawyers to do so?
Well, to date, I am not aware of any proceedings that have been brought. I would be surprised if that remained the case.
Why is that, Ms Warner?
I would expect that there would be some further investigations by our regulatory bodies, but it is really difficult for me in these circumstances to express a firm view because, of course, I don't know what the complete circumstances are here, and our general policy is not to comment on specific matters in the absence of a full understanding of the facts.
Yes. So we have a case study that's in the public place because of the work of the Senate about a particular matter that relates to PwC. But I understand that LPP, and certainly this committee's been frustrated by LPP claims, are being used to thwart the work of the ATO. And that they've been very public about the reality of being swamped by documents and obfuscation and interference with their work by people abusing this LPP term. I do note in your opening statement you referred to the Australian government's announcement that it's conducting a formal review into client legal privilege in Commonwealth investigations. But it's not just
we are participating.
Yeah, so what hope can you give the committee that there will be action? Because if people can make money and suffer no consequences, there is a drain on the ethical muscle that is being, dissuaded by the financial incentive to work in these big companies and use your legal qualifications to provide the sort of advice and information that is dissembling at best.
Well, it's entirely improper to make a claim for legal professional privilege which is not justified. And it should not ever occur, and if it does occur, there should be consequences for it. And there could well in the future be consequences in somebody's horizon. But there is one point that I'd also make in relation to the question about very large productions of documents can be fraught. I must say that when I was a junior solicitor, a small case had 5,000 documents. There are now millions and millions and millions of documents that get caught by regulatory notices. And it can be extremely difficult in regulatory inquiries to deal with them in an efficient way and to ensure that everything's done entirely appropriately within timeframes that are sometimes required in regulatory investigations. Now, that doesn't mean that improper claims for privilege should ever be made, but it does mean that sometimes the situation may be a little bit more difficult to manage than might otherwise be the case, or certainly was the case in the olden days.
I want to ask you a question about the currency of knowledge amongst the legal profession with regard to its intersection, not just with the courts, which I understand is a very significant part of making sure that our whole system, justice system, works and is a higher standard than many other professional bodies. But I wonder what the awareness is about the intersection of legal professional privilege, as it's often claimed, and the rights of the Senate and the House of Representatives to require documents. How well understood do you think that intersection is, Ms Warner?
I suspect outside those who are advising on production, responding to production of documents, it's not widely known. My expectation would be that there would be the provisions that would need to be complied with, and and the Senate is entitled to issue notices and people have to answer them.
Thank you. And I might just read into the record so there's no doubt. The committee asked for advice from the clerk whether legal professional privilege or the existence of confidentiality agreements prevents witnesses providing full and truthful answers to the committee. In short, they do not. So I want to ask for your assistance to encourage perhaps some improvements in the productivity of these committees. When the committees of the Senate and the House of Representatives call for documentation, it's not time for a legal battle about LPP. That just doesn't work here. We're serving the nation and not subject to those standard and important options that provide good counsel for people through legal professional privilege, generally outside of the Parliament. Can I take you to your opening statement once again? You support the introduction of reforms to remove the secrecy protections, secrecy restrictions that prevented the ATO and the TPB. That is a very significant reform. You've also indicated work underway to ensure that legal LPP is not misused. And I think, Mr Stevens, you spoke briefly to the changes in the nature of traditional law firm practice to multidisciplinary practices and operation within public institutions. What is your sense of what needs to happen at this juncture, given that this committee's inquiries into ethics and professional accountability, particularly with regard to audit and assurance and the consultancy industry? And that would be my last question.
Yeah, I would start off with the comment that legal practitioners have a number of professional obligations, and those obligations apply to all legal practitioners across the board, irrespective of the forum in which they're practicing, whether they're in a law firm, a corporate lawyer, a multidisciplinary practice. All those obligations are applicable to every lawyer who has a practicing certificate. Just to reiterate what was said before, lawyers are officers of the court and do have a paramount duty to the court and the administration of justice. Their first duty is not to the client, it's to the court. And that's a paramount duty. It's clearly expressed in various forms and in case law and so on. So those obligations have to be observed and even at the cost of the comfort of the practitioner operating in a particular environment they're in. So, and we have an extensive process of regulatory scrutiny of legal practitioners, and we have the law, as I think Juliana said before, the Law Council is not a regulator. The regulators are basically state and territory bodies, but anyone has a right to lodge a complaint or raise a concern about a practitioner and their conduct with the relevant Legal Services Commission in a different jurisdiction. And those complaints are dealt with by the regulator and quite regularly end up in court cases, tribunal decisions, which are all on the public record. And the right to make a complaint applies to every lawyer and also to every member of the public. And really, whilst the secrecy provisions have appropriately been changed to allow the tax office to and other regulators to raise concerns directly about practitioners with the regulators. It's a pity that wasn't there before, but it's always been open to regulators to go to the Legal Services Commission and raise concerns about how practitioners are operating, and it's always open for regulators, and they do regularly send alerts around and information notices to practitioners raising particular concerns about how things are done and so on. So the basic point is that lawyers are subject to strict obligations and to a high degree of regulation appropriately, and subject to disciplinary procedures. And to support that, the legal profession has various provisions, has made various provisions. We have the Australian Solicitors Conduct Rules, which are regulatory in nature, but we also, the Law Council of Australia has published a commentary to the 43 rules of the Australian Solicitors Conduct Rules. It's a 150-page commentary, so we go to great trouble to provide great information to lawyers about how they should handle various matters, including conflicts of interest and including legal professional privilege. And if one has regard to the commentary, you'll see that there's extensive commentary on the basic legal professional privilege and where it can be applied and so on. So in addition to that, most, if not all, of the state and territory law societies have ethics committees, and there is a procedure for any practitioner, whether it be a junior lawyer in a law firm or a partner in a multidisciplinary practice, to go to the ethics committee and seek guidance, and that's covered by an exception to the duty of confidentiality in Rule 9 of the Australian Solicitors Conduct Rules. So I'm just saying that there is an extensive web there which is designed to reinforce the importance of practitioners as officers of the court, with the paramount duty to the court and to the administration of justice to promote the law and not to promote non-observance of the law, to be supervised and for concerns to be raised with them. So
Thank you.
I hope that's helpful.
It is actually.
And I'd just
Mr. Stevens?
Sorry.
I'm just going to ask a question on notice, Ms Warner. If you could provide a copy of the conduct rules, the 120 pages that you referred to.
Yep, sure.
Ethics committees are where people report complaints. I'm pleased to hear that there's an opportunity for people to seek guidance and for privacy around that to be maintained so that they can do that without compromising their work, particularly in a multidisciplinary setting. How much work have you done on the power asymmetry that exists when you are a junior in a multidisciplinary firm where you're being told by a partner to basically, anoint a pathway that is at odds with professional requirements? This is where it really gets tricky. If I could ask you to take on notice, if you've got across the country any instances that reveal where that occurred, how that was managed, or is the sole work of these entities that you've talked about at state level simply really just people reporting failures post facto rather than, while it's going on?
Chair, if I can just respond to that, the role of those ethics committees is usually to make rulings on disputes or issues that have been raised. So anyone can raise a complaint on a confidential basis with the ethics committee, and ethics committees regularly make rulings, and in fact courts such as the Supreme Court of Victoria have deferred hearings on the basis of waiting for a ruling to be made by the ethics committee. So there is a forum for seeking rulings and for issues to be raised, and that would include the situation of a junior lawyer. That is obviously a very difficult situation. I think we're sort of happy to respond on notice, but the ethics committee is a forum where any practitioner can go and seek a ruling on a confidential basis.
Thank you very much. I appreciate you very much.
The matter the one matter I was going to raise is that there's an obligation for ethics continuing legal education every year.
Yes.
Topics are regularly around
the contemporaneous issues that emerge. Yeah.
Yes, exactly. And I know that in most firms, I certainly know in my firm, there have been regular discussions and so forth about the issues that are around. If you are asked to do something that you don't think is right, who can you go to?
Okay.
That's the kind of bit.
I have to wish you well in that work, because the legal profession clearly has a very, very different set of standards and requirements, as you said, to the court, officers of the court, which is very different from accountants who may be chartered.
Yes.
And associated with CANS or IPA or CPA, but other people can call themselves an accountant, and they can go out and do all sorts of things with impunity, frankly.
We're going to hear from some of your colleagues very shortly when we resume with our second inquiry of the day into financial abuse. So I'm going to conclude this session with you. Can I thank you very much for appearing and for your evidence today? Questions or notice should be provided by the 11th of October. And that concludes today's hearing. Thank you to all witnesses who appeared, to Hansard Broadcasting for their assistance. The committee stands adjourned and will resume at 11:35.
Thank you.
We will commence. I declare open this hearing of the Parliamentary Joint Committee on Corporations and Financial Services into the Financial Services Regulatory Framework in relation to financial abuse. I begin today by acknowledging the Ngunnawal and Ngambri peoples, the traditional custodians of the land on which we meet, pay my respects to their elders past and present, and I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing in person and via video conference. These are public proceedings being streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It's also contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy. They shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised, and a copy of that order is available from the Secretariat. I now welcome representatives from the Law Council of Australia via video conference. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
I'm happy to start, Chair. I'm Nathan McDonald, the Deputy General Manager of Policy at the Law Council Secretariat.
Thank you.
Senator, I'm Darryl Brown. I'm the Chair of the Elder Law Capacity and Succession Committee of the Law Council of Australia.
Thank you.
Chair, I'm Pip Bell. I'm a co-chair of the Financial Services Committee within the Business Law section of the Law Council.
Thank you.
Chair, I'm Dana Beglary, a member of the Consumer Law Committee of the Law Council of Australia.
Wonderful, thank you. And just so you know who you're giving evidence to today, two of my colleagues from Western Australia, Ms Zanetta Mascarenas, who really pushed the committee to undertake this inquiry, which was unanimously agreed, is with us, and my very experienced colleague also from Western Australia, Senator Pratt, who has a long and abiding interest in matters of justice and equity, particularly for women, is with us from Western Australia, and the Deputy Chair of the committee, Mr Alex Hawke, from New South Wales, who I know, like me, has been quite shocked by some of the evidence we've received in the course of our inquiry. We're all here, and I'm in Canberra in person. I understand that information on parliamentary privilege has been provided to you. You've indicated who you are. Now I invite you to make a short opening statement, and I thank you for providing that in advance for the committee to consider as you read it into the evidence. I propose to complete this session at 12:30, as was originally indicated. So over to whoever's giving us the opening statement. Thank you.
Thank you, Chair. The Law Council of Australia welcomes the opportunity to appear before the committee this morning relating to its inquiry into financial services regulatory framework in relation to financial abuse. We acknowledge the traditional owners and custodians of the lands where we are each joining from today, and we pay our respects to elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples who are in attendance. The Law Council supports the inquiry's focus on the role that financial institutions play in identification and prevention of financial abuse and the effectiveness of existing laws to govern the ability of banks to deal with financial abuse. The terms of reference of this inquiry are necessarily broad. While noting the wide range of material already considered by the committee in previous hearings, our written submission has focused on three core areas raised by our members: the prevalence and impact of financial abuse, areas of potential reform, with a particular focus on responding to elder abuse and family violence, and the role of the legal assistance sector and the importance of adequate resourcing. Financial abuse is regrettably a widespread phenomenon. In many instances, financial institutions may be the first to become aware of unusual transactions and are well positioned to detect financial abuse and act early to prevent it. However, as our submission emphasises, care must be taken to strike the right balance between consumer protection measures and the need for financial institutions to operate efficiently and effectively. One distinct area that the Law Council has focused on is the need to address inconsistencies in the way in which enduring powers of attorney are regulated. Enduring powers of attorney are often central in cases of financial abuse of older Australians, and the current variation of laws across states and territories in Australia makes it difficult for a wide variety of stakeholders, including financial institutions, to engage with the relevant legislation when trying to detect whether an attorney is acting beyond the scope of their powers. To the extent these inconsistencies lead to greater confusion and risk of financial abuse, the Law Council continues to call for nationally consistent laws relating to enduring powers of attorney and a national enduring power of attorney model document or form, which would then follow these reforms. On a related note, the Law Council has been advocating for reforms to the superannuation death benefit scheme. In summary, we're of the view that superannuation death benefits should form part of the estate of a deceased person, except where that person has made a binding death benefit nomination. This is an area identified previously by the Australian Law Reform Commission as in need of attention in its 2017 Elder Abuse Report, and we welcome the committee's consideration of the issue in the context of financial abuse with superannuation benefits. Other points made in our submission highlight certain areas where financial institutions may be able to improve in the identification of and response to financial abuse, noting that significant progress has been made in several key areas. A couple of areas where some further attention may be warranted are the expanded reliance on online platforms when interacting with financial institutions. This creates further opportunities for technology-facilitated financial abuse, and the critical role that ongoing training and education for individuals plays within financial institutions, especially in relation to issues of capacity and supported decision-making. Finally, we continue to raise the issue of legal assistance funding as a key part of responding to the challenges of financial abuse. It is critical that legal aid commissions, community legal centres and specialist financial counselling services are adequately resourced to provide support to those who are at risk of or who have experienced financial abuse. While the government's announcement earlier this month on the new National Access to Justice Partnership is welcome, more investment is needed to ensure these services can address the unmet legal need that currently exists, including in relation to financial abuse. A core recommendation made by the independent reviewer of the partnership was to address persistent gaps in civil law assistance, first identified by the Productivity Commission in 2014. Addressing financial abuse falls squarely into that category, and the announcements made to date are unfortunately far from sufficient. So to assist in directing questions today, as noted, I represent the Business Law Section's Financial Services Committee and can respond to questions relating to financial services regulation. I'm joined by Mr. Darryl Brown, who chairs the Law Council's National Elder and Succession Law Committee, and he's able to speak to elder law issues. And Dana Baglari from the Legal Practice Section's Consumer Law Committee is well placed to speak on civil and consumer law matters. For specific areas not covered in our written submission, but which have been raised in earlier hearings, such as family law, we may have to take questions on notice and further consult. However, we will do our best to provide timely responses following the hearing. Thank you again for the opportunity to appear, and we look forward to responding to your questions.
Thank you very much indeed, Ms Bell. And I'm going to go straight to Senator Mascarenhas for questions. And then Senator Pratt has indicated she has questions too. Ms Mascarenhas, you've got the call.
Thank you very much. And thank you for your detailed submission. In your submission, and this is probably a question to Mr Brown, one of the mega trends that you referred to was around the old age dependency ratio increasing over a 40-year period from 27% to 38%, which basically is an indication of our ageing population, but the number of people supporting that cohort. We also have $3.5 trillion of wealth being transferred over the next 20 years. Do you think that our laws are currently fit for purpose to prevent elder abuse? And if not, what do you see being the top maybe one or two legislative changes that we need to make?
The short answer to the first question is no. The answer to the second question is I think there needs to be consistency with enduring powers of attorney across Australia. Ideally, then there'd be a model form that could be developed, and ideally then there'd be a register where those model forms, which complied with consistent legislation, could be easily accessed. But I think it needs to be in that order, which is the order, by the way, recommended by the Australian Law Reform Commission in their report on elder abuse and a national legal response in 2017. I think the second thing is in relation to superannuation death benefits. Unfortunately, that's becoming a bit of a honeypot for attorneys doing the wrong thing, and potentially other people who are not formally appointed as agents, as attorneys, but are informally appointed but nevertheless have the ability to sway the member. And I think there needs to be some reform in relation to that area as well.
So in relation to the enduring power of attorneys, do you see that there's a particular state or jurisdiction that has good laws? And I recognise that there's still the need for harmonisation across the states, but I'm wondering if there's some principles that show what best practice looks like.
There are very different responses to legislating about powers of attorney in the various jurisdictions, and the difficulty that's been found in trying to get some consistency is which of those models is the best. So just to give you a very simplistic approach to that, in Victoria and Queensland, there's an approach which is sometimes called the codification approach. It actually tries to put into the legislation everything that potentially an attorney could do. And in doing so, it will alter the common law in some respects. And so, for instance, the legislation in those jurisdictions is 150, 160 sections long. Now, that's a very superficial way of looking at it, but it just gives you an indication of the depth and the complexity that's involved in those jurisdictions. And to give you a contrast, in New South Wales, there's 60 sections. In South Australia, there's 15. In your home jurisdiction, I think there's something like 167 active sections in relation to this area. So which of those approaches is best? Is it the light touch that's taken, for instance, in New South Wales, where you basically only do through legislation what's needed and allow the common law to operate otherwise? Or is it the codification approach? Now, those, unfortunately, are difficult philosophical issues. And so to my way of thinking, neither of those extremes are really suitable. The Law Council put forward some proposals, I think it was in 2021, where we basically said, let's use some recommendations that came out of the South Australian Law Reform Institute's report on powers of attorney, and let's see if we can look at those which are essential for addressing elder abuse, and really leave it to jurisdictions to work out what they want to do in relation to these other matters. And as a result of that, we pared it down to basically 6 different things that really should be included in consistent legislation. Now, none of the jurisdictions address adequately, in the Law Council's opinion, address adequately those 6 issues. So we put them there. We put them in a little bit of detail so people can look at that and sort of analyse it. But if those 6 aspects were included in every legislation in the 8 jurisdictions that are relevant across Australia, then we go a long way to assisting principals preventing their attorneys doing the wrong thing.
One of the things that I'm interested to understand is the scale of the problem. And so we understand what's going to be happening over the next 20 to 40 years. For one of our witnesses that have participated in the hearing, they described this inquiry as one of the most exciting things that she had witnessed from a parliamentary perspective. And specifically, it was around the inconsistency of power of attorney legislation. How big is this problem? And I guess from a parliamentary perspective, we need to prioritise things in order of how much of an issue it is for our community. Can you give us a sense of the scale of, let's say, elder abuse and specifically the abuse of enduring power of attorney?
Can I just introduce this by making this statement? This was a recommendation in the Australian Law Reform Commission report that I recommended that was tabled in June 2017. In 7 years later, we are still talking about that recommendation and nothing has occurred, even though it's been before the Standing Committee on Attorney General on a number of occasions. So that's how difficult it is from the policy point of view. If we go to the tribunals, and the tribunals in each of the jurisdictions are the main ones where elder abuse is seen, because to go to a Supreme Court, it's often a very expensive proposition, and people only do that when they're desperate or there's significant money involved. But with tribunals, they commonly see it. You will see in every week there's a significant case before one of the tribunals across our jurisdictions where elder abuse is raised as an issue. Now, it won't always be resolved, because what will happen is the tribunal will be so concerned about the possibility that, in fact, the person who's the attorney will be replaced. And some stage later, it may well be that the replacement person, the financial manager, administrator or whatever, will make inquiries and take action. But that's the scale of the problem. Now, if we then look at those statistics around an ageing population and the wealth that's involved with that ageing population, and we then try to extrapolate how that's going to have an effect on society, we can just, put a power of 3 or 4 or 5, quite frankly, to the existing issues.
Thank you for explaining that. The other area that you talked about was around superannuation, and I'd say going into this, I hadn't anticipated that superannuation would be a product where perpetrators could commit financial abuse. And I'd say that we've seen it from maybe 2 perspectives. One is from a family domestic violence perspective. The other is from an elder abuse perspective. Could you maybe talk about some common examples that you see, but what you think needs to change from a legislative perspective to make sure that we're looking after the holders of superannuation and not perpetrators, but rather victims?
I think there's 3 circumstances where the member can be pressured to do the wrong thing, or somebody acting on the member's behalf, such as an attorney or even an informal agent in some circumstances, can do the wrong thing purportedly on behalf of the member. The first is when there's a condition of release. So if a person's 60 and retired, or if they're 65, whether they're retired or not, the member can take the money out of the superannuation. Now, that, of course, can then it can then be used in any way that the member wants. Now, there's not a bad thing about that as a matter of philosophy, but of course it then allows that to be abused by a person who's over 65 and may, as a result of that, becoming increasingly vulnerable. The second is in relation to rollover. You and I can roll over our superannuation funds, or at least I can, I'm not sure about yours, into another superannuation fund if we wish. And that's not a bad thing if we're in a poorly performing fund or a fund that's engaged in misconduct. Then I would not want to be a member of that fund, and so I should be able to put it into another fund. And so potentially can my attorney or somebody acting informally on my behalf. The trouble with that is putting it into a self-managed fund, because what happens in a self-managed fund is rather invisible. It's not really transparent. The tax office is interested in the fact that it's a complying fund and the tax is paid and it's not being abused for self-interest, but otherwise is not there to monitor the actual conduct of the fund. And so there's been some Supreme Court decisions where it's been found that, in fact, attorneys have done the wrong thing when money's been rolled over into a self-managed fund. And the third aspect is in relation to nominations. You and I can make a nomination for our superannuation fund, and but who we nominate in that regard is reasonably limited. And it just seems to me it may be better to reform that area. This is something that's been suggested again by the Australian Law Reform Commission. The Productivity Commission has also made recommendations about reform. It was part of the, in a peripheral sense, it was part of the recommendations out of the Royal Commission into Misconduct into banks, financial institutions and superannuation entities. So it really is something that should be looked at carefully about when can nominations be made, who can be nominated, and what overriding purpose is being served by that.
Thank you. I'll now talk about the family court, and one of the things that we sometimes hear from victim survivors is court proceedings taking a very, very long time and perpetrators strategically dragging out the proceedings to inflict further abuse on victim survivors, and other kind of structural barriers to try and find good resolutions and justice. Is this something that you see as a common issue, and is financial abuse taken into consideration of cases?
I'm happy to
answer that.
I'm happy to at least attempt to answer the question, noting that we don't have family lawyers here on the call, but certainly following the committee's proceedings, there have been obviously some very strong stories, and I must commend the committee for this inquiry and the courage of those individuals that have expressed and shared their stories. The idea of expedited family law proceedings to avoid some of those delay tactics, I think, is something that we would certainly support. Obviously, the devil would be in the detail, but we've seen, at least in the family law space, an attempt to bring forward and prioritise particular cases where there is identified family violence, particularly in parenting matters. The Lighthouse Project in the Federal Circuit Family Court is a good example of that, and that's something the Law Council supported. Whether or not it could be duplicated with respect to post-separation proceedings, may come down to resourcing of the family court, but it's certainly something we can go away and think about and come back to you.
Can I just jump in for a question there, Ms Mascarenhas, while we're on that topic? We just heard in an inquiry into ethics and professional standards with regard to our inquiry into audit assurance and consultancy services, that the professional responsibilities and the ethical responsibilities to uphold justice and the law through the courts is a primary responsibility. That is what is required of every single lawyer in every circumstance, no matter what structure they're employed in, no matter how big or small the practice. That is a fundamental requirement, ethical action. Can I suggest to you that the stories that we are hearing about the use of lawyers to weaponise the domestic law situation is an engagement process that is filling the pockets of lawyers and putting women on the street homeless. And while you've indicated, I think, Mr McDonald, interest in this matter, I think we need to get back to the primary reason why this is being enabled. You know, rather than waiting for the Attorneys General and the public purse to come in and provide further assistance, this needs to be stopped at the point of commencement. Like, where is the ethical muscle? Where is the professional responsibility of lawyers who are making a mozza out of extending legal cases that are causing incredible financial abuse, the continuation of coercive behaviour? So I'll put that question to you.
Thanks, Chair. It's a very good question. Perhaps I can answer in three parts. The first is, I think it's fair to say there's been a really increased understanding and public dialogue around coercive behaviours, which includes things like systems abuse and abuse of the legal system that you referred to. That's probably evidenced by the National Plan to Protect Women and Children, yes, which is in its third year, that explicitly refers to abuse of particularly the family law space. That's something that didn't appear in the previous National Plan, to my knowledge. So there is an increased recognition. My colleagues that appeared at the previous hearing did talk about the paramount duties and responsibilities of the legal profession. Very much does go to administration of justice and duties to the court. And as my colleagues at that time mentioned, there are complaint and disciplinary frameworks in place at the state and territory level, and it would be expected that lawyers that are breaching their professional ethical responsibilities in that regard would be held to account. Can
you take on notice how many times that has occurred? Because I don't want to take away from the time for my colleagues to ask questions. How many times has that occurred? Because it seems to me the disincentive to act in the interest of the law is being trumped by the interest to act by the incentive of monetising a service that is perpetuating and exacerbating financial abuse, and indeed, based on the evidence we've received, driving people to what we had described to us last week as suicide by domestic violence. Right? That is a big thing to say.
Yeah, I appreciate that, and happy to take it on notice, noting we'll just engage with the regulators
for
on
each
that point.
Jurisdiction where that's been found and where it's been attended to. Back to you, Ms Mascarenhas, and then we'll go to Senator Pratt.
I wonder if you wouldn't mind, Chair and Senator, if I just added something from a practitioner perspective. So I'm a civil practitioner, and often our assistance and representation of victim survivors with their credit matters is delayed because of delays in the family court. And you may have heard before evidence of how property proceedings in the family law court may be linked to a claim in respect of financial abuse, perhaps relating to the family home, and hardship that might be related to that loan contract. Often our work is delayed in terms of progressing the matter and getting an outcome either directly with the financial firm or in the financial ombudsman because we're waiting on outcomes in the family court.
And if you could put your mind to what a solution to speed that process up that is low cost and actually doesn't have to involve getting a lawyer for people who have no experience of the law, that would be also helpful. Ms Mascarenhas.
This will be my last question. One of the things I'm curious to understand is whether, from your perspective, whether the community, banking and legal sector know enough about financial abuse and how to deal with it. And I'll give you one of the quotes from one of the submissions that we received. Everything I had disclosed was clearly family violence, but I actually had to use that term and say that I was going to court for a family violence intervention order and cry for the bank to suddenly act to help me. And so that quote kind of, what it demonstrates is that she was basically showing what the elements were, but she didn't use the language that the bank needed to say. And so she wasn't getting the support that was needed until that was actually explicitly said, which is often quite challenging for victim survivors.
Senator, maybe I could start our comments and my colleagues may have further comments to make. In our experience working with victim survivors, unfortunately, it's not uncommon for victim survivors to have spent a significant period of time trying to advocate on their own behalf and explain their stories to financial firms, often to multiple teams and multiple financial firms, in particularly egregious cases of financial abuse, without any outcome. And they come to services, for example, I work for Legal Aid New South Wales. They come to legal aid commissions and specialist community legal centres for assistance. And at that point, we're able to understand the client's experience and talk to the client about her, often her obligations and rights and the responsibilities of financial firms under various guidelines and voluntary codes of practice. And unfortunately, it does feel sometimes that we might be using the magic words with financial firms in order to get an outcome. But our experience of getting a positive outcome in circumstances of financial abuse is very inconsistent. My experience is that generally larger lenders, so larger banks, do have good internal processes and training around financial abuse, but that's very varied across the sector, and sometimes it depends on which staff member you're speaking to within the financial firm to get a fair outcome for the victim survivor.
Can I just add one more question, which is around culturally and linguistically diverse clients, and whether you find whether there's an under or over representation of those particular clients, and whether you see barriers for that particular cohort of people.
I would say that financial abuse really does affect everyone, and I see a range of demographics and cultural backgrounds with the clients that I've been working in as a legal practitioner. But certainly people from culturally and linguistically diverse backgrounds and also First Nations backgrounds may have particular issues with financial abuse and difficulties advocating as vulnerable because of perhaps their communication difficulties or specific cultural practices. They might have difficulties advocating on their own behalf with financial firms. The other group that I would add to the list is people that are regionally and remotely based, where it might be very challenging to reach a legal or community support service to get that support in advocating for a fair outcome.
Thank you. I'll share the call now.
Thank you very much, Senator Ms Mascarenhas. Senator Pratt, you have the call.
Thank you, Chair. I wanted to ask, we've had overwhelming evidence of the size of the job that we need to do in reforming laws and institutions to take seriously financial abuse. And when I think about trying to get through a reform program that highlights the work that's already been raised and the things that haven't been done from previous inquiries and the fact that this issue is not going to go away, I want to ask you where you think the leadership for these issues should be embedded. For example, we have ASIC commissioners to oversight the Corporations Act and banks. We have the ACCC, which is about protecting consumers in a competition sense and to protect consumers in consumer law. But we don't see that these same bodies have a structure where they prevent the systems they oversight to really prevent products or laws from being weaponised to cause harm between consumers at that kind of domestic financial abuse level. So I wanted to ask you, we've now, of course, got a commission for the prevention of family and domestic violence to protect women and children, and they too really just seem to be only starting to ask themselves questions about what leadership in this space should look like. But I would really hope, for example, that this inquiry could accelerate that and perhaps suggest that ASIC have a specialist commissioner around financial abuse, the ACCC have one, and that the ATO also have one. And I wondered if what opportunities and challenges you would see in doing something like that.
I guess I can make some observations around regulators. So ASIC is the regulator, I guess, that I have the most experience with. Once upon a time I was even a staff member. But there is obviously a corporate plan that regulators are required to produce every year, and they will have... I know that protecting vulnerable consumers is one of ASIC's strategic priorities. Recently, focus has been protecting vulnerable Indigenous consumers. Similarly, you'll recall ACCC took some action against Telstra for some very egregious practice that took place in northern Western Australia several years ago, and a substantial remediation program has taken place. I think, Senator, your suggestion about having sort of an accountable individual within an agency, and for the agencies to talk to each other, particularly with this new commission, would be helpful. Often regulators will have memoranda of understanding between each other to allow them to share information and cooperate. But I think if there are common shared priorities and there is an open, maybe structured line of communication to regularly discuss the issues, report and share progress, then that would ensure that things don't just sort of come and go from headlines quickly, but that there's an ongoing focus, because there's crisis responses and there's litigation and so forth. But when there's sort of an ongoing systemic issue, and when we acknowledge that it is the system, that there are features of the system which are heavily contributing to the incidents, then I think a holistic approach among government definitely would be warranted and helpful, and having people who have it as part of their responsibilities and who are dedicated to that particular objective, I think it's a very sensible solution.
Thank you.
Would it be possible, Senator, just to add one observation to Ms. Bell's comments? I think as part of that idea, which I think I agree is a good one, there'd need to be very clear assessment that the regulators have the requisite powers that they need to effect change, and in terms of using the law now as a practitioner, it can be quite challenging to get an outcome for a victim survivor using the current financial services laws that are available. So I just suggest close engagement with the regulators about what powers they feel that they could use, and if they would need more to affect the change that we're talking about.
Senator Pratt, can I interrupt to ask to put one on? Yeah. I just want to put one on notice because there's not going to be time. I want to refer to a scholarly article by Susan Barkhall Thomas et al., Intimate Partner Economic Abuse in Loans and Guarantees, an empirical review of 10 years of cases. This is an Australian study, and it contends that equitable doctrines and statutory protections do not provide sufficient protection or adequate means for legal redress. It states that the role of independent advice is very limited as a tool that's being used by banks. We demonstrate that a significant reason why victims are unsuccessful is due to the independent advice requirement, which we argue fails to provide any real avenues for vulnerable parties to disclose or report the abuse. Instead, it enables lenders to rely on a process which is frequently formulaic to satisfy their legal obligations. Can I ask you to have a very close look at this document, which I think is a disgraceful and very, very concerning reveal of the inadequacy of a pathway to hold lenders to account that requires not just regulators, but significant change to law to make sure that the lenders are on the hook for not observing financial abuse. So that's a question on notice. And while I'm doing it, can I get you to look at 3 other articles? One of them is the PM&C article supporting women's financial safety. The other is a KPMG article that was commissioned by the Department of Prime Minister and Cabinet in 2020, which describes all sorts of financial abuse behaviours. And ask how aware, like how deeply aware are your practitioners of things like, financial abuse behaviours of the perpetrators, because hopefully many of them don't have the experience of being financially abused themselves. But we're talking about people who will constantly phone somebody at work, turn up at work and stalk people, arrange for people at her workplace to spy on her, forcing her to resign over the telephone, not allowing her to have any money, not giving her any money, taking money from her bank account, taking money from her purse, making her justify why she needs money, using ability to withhold money as a source of power over her, for example, sexually exploiting her. They're the kind of people that we're talking about at the other end of this financial abuse. If they're doing that, and they can get a lawyer on board to help continue post-separation, the legal professional really needs to be really skilled in observing these behaviours and have a path of response that is appropriate when this is the kind of person that they're engaged with. So have a look at that. And also the article, The Weaponization of Child Support in Australia, which is by Cook et al., came out of Swinburne University. So the Secretary will be in contact with you with regard to that. But each of these articles, I think, talks to the post-separation escalation of financial abuse that was embedded in the relationship before the separation for the majority, and for those who haven't had physical or financial abuse prior to separation, the commencement of a multi-year form of abuse enabled through the legal system, facilitated by your practitioners. So I ask you to respond to those. I'll go back to you, Senator Pratt. Thank you.
Thank you very much. I don't know whether the other areas from the Law Council had a response to my question, but I also wanted to ask in that context as well about, I guess, the experience of the Law Council. Of course, you have to build up your own specialist areas, but really about that intersection of family violence and financial abuse, and any of the learnings there in the context of coercion and control.
I can try to answer that, Senator. We're very engaged in policy reforms that have taken place over the last few years in relation to coercive behaviour. We have a family law section that is very attuned to these issues. There's some examples that could perhaps give. In 2019, there were some significant reforms that prevented self-represented litigants in the family law space from cross-examining their former spouse, which we supported. The reforms to the Family Law Act last year included hardship proceeding measures, came into effect May this year, where it provides the court with greater powers to intervene where copious applications in the family court are deemed to be harmful. And that includes financially harmful as well. There's family law reforms that are currently before another committee that are looking at observing financial and family domestic violence in property settlements and distributions. We're very engaged in those processes and have an acute awareness of the intersectionality between family domestic violence and the family law space. And we continue to interact with these reforms. Sorry, Sonia, you're just on mute, I think.
We've had a crisis for some time in relation to family violence, but it seems to be the interventions around it are around the relationship and violence itself, and whereas it hasn't really been emphasised the extent to which financial abuse might be very much packaged in with the type of abuse that's occurring in the instances of family violence, and that in fact preventing financial abuse will in and of itself make a contribution to preventing acts of physical violence. And I guess I'm wondering what you think that evidence base looks like, because to get this financial abuse prioritised, we will really need to unpack those intersections.
Yeah, please, anyone feel free to jump in. One point I would make is just the important role of the community legal sector in ensuring that individuals are aware and can enforce their rights in this space. Yeah. I think I mentioned earlier that this is an area that I think there really is growing awareness as to what coercive behaviours are and how a subset of that can be financial abuse. It's all very well for that awareness to increase, but individuals subject to some of these behaviours need to be able to be advised of their rights, need to be able to enforce their rights. So I take the Chair's comment earlier about the public purse, but we really reiterate the importance of a properly funded legal assistance sector and see that as a really fundamental role in addressing some of these challenges.
How often would it be, for example, in the context of a community legal centre supporting someone who's experiencing family violence, to have to take the time to have quite take the time to unpack a person's experiences to discover that they are most often also being subjected to financial abuse, which they hadn't really identified as a form of abuse like family violence?
Maybe I could offer some reflections from the Legal Aid Commission perspective. That is certainly my experience as a practitioner and my colleagues' experience, and it's essential for our organisation to have a close working relationship between the family lawyers and the domestic violence lawyers who deal with the acute family court proceedings or physical abuse issues or care and protection issues that might come up as a result of family and domestic violence. It's important that we have close connections with those teams so that we can then assist with the financial abuse parts of the victim survivors' issues to work through. One victim survivor client said to me, her partner had told her, "You'll never be rid of me," when he told her about the list of loans that he had signed her up for when she was leaving the relationship. And he meant that in so many ways, because it took us months and months and months to unwind all of those loans and to remove the evidence of it from her credit report so that she could obtain credit and rebuild her life as a single mum with 3 kids from a culturally diverse background, so that she wasn't hassled by debt collectors, so that she didn't have to think about making repayments to loans that she didn't receive the benefit of. So it very often goes hand in hand. And I think, as Nathan was saying, it's essential that the legal assistance sector that has specialisation in working with victim survivors who have many different have experienced many different kinds of abuse. It's essential that those services are adequately and consistently funded.
Thank you. Thank you, Chair.
Thank you very much, Senator Pratt. Could I ask if you have any research as the Law Society about the gendered nature of who engages with which parts of the legal sector? I'm not a lawyer and I don't work in this field, but predominantly the evidence we seem to be receiving is that women need to draw on the scarce but important resources that have been further enhanced by recent commitments by the Attorney-General. They need to draw on the community legal sector, but that the perpetrators of financial abuse somehow manage to have sufficient financial resources to draw on the private legal sector to represent them and to help them assist to perpetrate that abuse. Do you have data about the gender difference of engagement with those two different providers of legal services?
Short answer is no, Senator, not to my knowledge. It's something I can go away and have a look at. I think there's obviously women's legal services as a subset of the community legal sector. So that is one cohort of consumers. But in terms of the gendered nature of across the legal profession, that's something we need to have a look at further.
Could you take on notice if there's any academic research that might have attempted to diagnose or discern from evidence how many men are actually being represented by private providers as opposed to women being provided support from community legal services, which we know are very difficult for some to access? So take that on notice if I could.
Certainly.
We have had evidence that the nature of families have changed quite significantly. So when we have a marriage and divorce structure that is mirrored, but perhaps a little less formally, between a de facto and a separation declaration, could you provide or notice some sense of how a declaration of separation would operate, because it's not a formal divorce? How does that change the interaction between people who are experiencing the dissolution of a relationship, an intimate partner relationship where DV and financial abuse as a form of DV is evident? In situations of divorce or separation, what guidance is provided to ensure that the legal system is not utilised as a method to drain the financial resources of the former partner and to perpetuate a power imbalance and financial abuse? Are there any professional obligations, any fiduciary responsibilities in the legal professional to ensure that they don't further serve abusers?
Senator, Chair, there is certainly the professional ethical responsibilities go to administration of justice, and there are overarching responsibilities as an officer of the court for lawyers not to abuse processes. I think it's very difficult.
You're going to take on notice to find out if there have been any infractions that have been attended to and people who have been punished or dismissed from the profession because of this practice?
Yes, I think we've agreed to take that on notice.
Thank you. Could I open up one further line just in the 2 minutes that remain? How could the usage of trusts be implemented to further or used to further financial abuse, including through the disguising of assets and the creation of a vehicle of power that can be perpetuated by the legal system? What role does the legal system play in terms of oversight and prevention? How can trusts, which we understand are proliferating and do have a very useful purpose, but appear to be ripe for abuse, particularly in the transfer of intergenerational wealth and also for high wealth individuals to hide money and to use as a tool for abusing a partner who might want to flee? How can trusts be structured to prevent undue influence and power imbalances? And how can trusts be structured to ensure transparency, especially for those who may have a claim on assets?
It's a big question, Senator, with the time available. I'm happy to take that one on notice. I do know that the Attorney General's Department has been working on a number of measures in relation to increased transparency over asset pools, particularly in separation proceedings. I certainly know that's the case in superannuation, and I believe there might have been some work done around broader assets as well. I understand AGD might be appearing this afternoon. It might be something that they can speak to.
Thank you. There will be some questions on notice. Can I thank you all for the work that you do, and particularly in your roles, not just as professionals, but serving your profession through the Law Council. It's a very important role, and we appreciate your insights and your breadth of knowledge across the sector. If I could ask you to respond to any questions on notice by Friday the 11th of October, that would assist the committee. The committee will now suspend until 1:15. So, social services and service. It's all right. I make that noise quite frequently myself. The committee will resume. I now welcome representatives from the Department of Social Services and Services Australia. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today? And we might start down there with you, Ms Robinson.
Jodie Robinson, General Manager of Child Support and Tailored Services, Services Australia.
I'm Tony Piazza, General Manager of Families, Indigenous and Tailored Programs, Services Australia.
Thank you.
Hello, Kathy Toes, General Manager, Working Age and Pension Programs Division, Services Australia.
Kirsty Fashni, Deputy CEO, Program Design, Services Australia.
Good afternoon. Patrick Burford, Group Manager of the Communities Group in the Department of Social Services.
Ben Peoples, Group Manager, Participation and Family Payments Group in Department of Social Services.
And Anna Lutz, Group Manager, Ending Gender-Based Violence in the Department of Social Services.
Thank you very much. I'm sure that you're very aware of and participating in incredible work that's underway with regard to the end of violence against women. And I really note the Supporting Women's Financial Safety Guide to Prevention of Action on Financial Abuse within the financial services sector, which I know is part of the consideration of the departments in your work. Can I just take you in my first question to your awareness about the weaponisation of government agencies in the perpetuation of financial abuse?
Ben Peoples, yes, we're aware of that issue. Obviously, it's an issue that's been covered, including through recent National Cabinet meetings, and it's an area we're looking at particular to the social services portfolio in relation to social security payments, as well as in relation to the operation of the child support scheme.
Thank you, Mr Peoples. So with particular regard to the social security payments, do you want to explain the system, how it operates, and how that is being weaponised?
So social security system is a range of payments that are provided to provide a safety net for people in Australia. That includes a range of working age payments, payments like job seeker payment, parenting payment, as well as pensions like disability support pension, age pension. Australia's social security system is quite targeted in nature, with a range of income and means testing arrangements to ensure that it's directed to those most at need. And an important part of the system as well are the range of supplementary payments that an income support recipient may be eligible for, things like Commonwealth rent assistance, pharmaceutical allowance, and others. While there's not a specific payment in the social security system that is available for victim survivors of family and domestic violence, there is a crisis payment, which is a payment that's available to income support recipients at particular points of crisis or emergency, and one of those is for people who are leaving their home as a result of a family and domestic violence incident. In addition, there are also a whole range of exemptions and policies that are in place to ensure that support is available to victim survivors at particular points of time. Things like exemptions from income tests, the ability for special circumstances, waivers to be applied to debt, and a whole range of things across the different payments that is available to support victim survivors at different points of the cycle.
So it sounds like there is quite a lot, but it seems from the evidence received by this committee that that is still not sufficient to actually ensure that women aren't sort of being financially abused into homelessness. And indeed, we've had evidence in our hearing last week that suicide by domestic violence was a term that was put before us, that the hopelessness of engaging with all of the streams of abuse, the multiplicity of streams of abuse that are being operated by the perpetrator over long periods of time, can only be sort of touched, not solved, by the very important supports that you've described, Mr. Peoples. One of the issues that's been raised I'll give you a chance to respond, but also one of the issues that's been raised is the intersection of information sharing with regard to family tax benefits. Can you speak to your awareness of that problem?
So I guess in regards to your first question, I think it is fair that there is a need for us to look at how the system does operate, and particularly across payments. We work with organisations like Economic Justice Australia and note that Economic Justice Australia have acknowledged how critical social security can be to victims of violence when they are re-establishing themselves, but that there are areas of both policy legislation and how we work with recipients of payments that can be considered, can be improved, and that's a significant body of work that we've got underway at the moment. In relation to the family tax...
And are you doing that just within the Department of Social Services and Services Australia, or are you interacting with other government agencies or other entities outside the government structures? Ms Lutz.
Senator Anna Lutz, Group Manager Ending Gender-Based Violence. On the 6th of September, National Cabinet released a communique that confirmed that there would be a Commonwealth audit of government systems. That is being led by Prime Minister and Cabinet through the Office for Women, so they will be better placed to answer more questions if this committee has that on that review. But that they will work very closely with us in DSS and Department of Social Services, including Mr Peoples and my area, as well as across the Commonwealth, Senator.
Okay, that's very good to hear. I know that people were very heartened by the announcements that came out on the 6th. And I think at this point of time there's been a reflection because of the reporting of so many deaths, that we just can't allow that anymore. But the intersection of the deaths from physical assault with the ongoing and ever intensifying forms of financial abuse that have been documented in the course of this inquiry, I think is just becoming something that's becoming more visible to Australian people, and our systems have been blind to it for some time. I think, is that a fair assessment, Mr. Peoples?
I think it's an area that we need to look into more deeply, and that's what these audits will do, and particularly consider how some of our policies and processes intersect across different government systems as well. I think in relation to kind of who we're working with in looking at these issues, there are a range of stakeholders, but particularly Economic Justice Australia has been an organisation that we have really valued their contribution to providing feedback about how policy works on the ground and how that impacts individuals who are receiving payment. I'd point to a few. There's obviously quite a lot of work we still have to go, but over the last year or so we have worked with EJA and our colleagues at Services Australia as well to change what is called the Social Security Guide, which sets out a range of the policy operations for how payments are administered and how recipients can be eligible for payment, and have made amendments in relation to how assessments are made for people who are treated as member of a couple to ensure that circumstances of when a person is in a family, domestic or sexually violent relationship, that gets considered in a member of a couple assessment, and that victim is not then negatively impacted as a result of either income tests or income reporting or asset tests going forward. So, have worked with EJA as well to introduce a more modern, up-to-date definition of family and domestic violence. So I think there's some work that we've done with some of these stakeholders. There's a considerable amount of work to do as well, but that's what we're keen to do both across social security and the child support schemes.
Yeah.
Senator, I might just add, Patrick Burford here, Group Manager of Communities. We, out of my group, we fund quite a few services in the non-government sector and charities groups in terms of financial counselling, emergency relief, food relief. And to your point about the collaborations, there's certainly work underway and more work to do on how someone entering and engaging through those services are made appropriate referrals. So financial counsellors are well trained in making referrals to other services, be it through Services Australia or through 1800 Respect and the like as well. I still think there's work to do on how those services connect with each other. They make appropriate referrals to no-interest loans that's made available, including for people escaping domestic and family violence. There's financial literacy programs out there to help build resilience, etc. So there is some investment through the non-government sector as well as through government services. But I think it would be a fair point to make that there's some still work to better understand how those referrals and connections are made. So it's a holistic service, no wrong door type of approach with those services. But we're seeing some really good cases of where they're approaching that holistically.
I appreciate that is happening, because that is going to be really significant for people. But if I can put it this way, with the ambulance at the bottom of the cliff analogy, that we've taken evidence from the banks that if a couple are banking with one bank and all of their accounts are there and there's malign action, the bank can make an effort to rectify that if they're advised. We've heard some concerns about, what you have to say to actually get the bank to notice, and that the big banks are better at this than the smaller ones. So we've got a few issues there. But the problem really escalates when the couple have a bank account or a range of bank accounts with different banks, and at the moment there is no way for a bank to observe, despite the fact that we're transferring money all the time between all these entities, no way for the banks to observe where money, in particular, might be resting. And there's no way for your departments to observe where assets are being held. And it seems to me there might be some impediments for you seeing into trust structures, particularly family trust structures, which are being used, or to superannuation. What thought are you giving, and what recommendations would you give to the committee about, how those blind spots need rectification so that fewer people end up at the bottom of the cliff? They all deserve the support when they get there, but the scale of people falling to the bottom of the cliff just seems to be getting bigger and bigger. So how do we interrupt this?
I'm not quite sure how to respond with regard to the government's engagement with the banks. That's usually handled through our regulatory areas of government rather than our agency per se. But
do you talk to those regulatory agencies? Do you let them know?
So I can speak. Sorry, Ben Peoples. I can speak to in relation to the operation of the child support scheme, and obviously for child support. Some of those issues are really critical because tax lodgement is such an important part of ensuring that the child support scheme kind of meets its objectives to support children and to provide that financial assistance, and tax assessments are that kind of key point where information can be provided to Services Australia to calculate accurate child support assessments. And so we do work really closely with both Services Australia and the Australian Tax Office. We have, as part of some of the work we're undertaking in response to the recommendations of the Family Law Inquiry, established a number of review processes, including one which is looking at compliance within the child support scheme. And so there is a working group that has been established between DSS, Services Australia, ATO and Treasury. The Australian Tax Office is also a member of the Child Support Stakeholder Consultation Group, which hears directly from a number of key stakeholders, including some that I know you've also heard from, like Single Mother Families Australia, which DSS co-chairs with Services Australia. And so both in terms of how we work together to hear the feedback from people with experience, we do that in a shared way so we can have that consistent feedback coming into us, but we also have a number of processes in place to work across the different agencies.
The great thing about coming to Canberra from a different part of the country is what I see when I get here is quite different from interactions I might have with people across the great state of New South Wales when I'm door knocking, with very, very different access to stable jobs and different levels of education, and a lot of the lawmaking goes on by people who abide by the law and approach making the law and the rules and regulations and systems for a moral code that they are operating out of, which makes them good citizens. But can I just read to you some of the descriptors of people who are perpetrating financial abuse in a report that was at Literature and Desktop Review, Appendix E, provided to the government of the day in July 2020, that we're talking about people who stop their partners from doing things with regard to, work and employment, destroying the phone so work can't contact them, destroying her clothes, ripping clothes off her, keeping her up all night, doing things so that she misses the bus, arguing with her every morning, taking away money given to her, preventing her from accessing benefit money, including child benefit, intimidating her into giving him money, ripping up her money, pawning her possessions, setting a figure to cover certain expenditure, deciding how the money should be spent, pre-approving shopping, checking the change, checking that goods have been bought. These are the people that are weaponising our systems They are not operating out of the same moral code if they're already there before separation. And the concern that we confront now is that post-separation, according to data from this research called the weaponization of financial abuse, indicated that 80% of women reported their ex-partner had replaced physical abuse with financial abuse via child support. That's like the big bludgeon stick that gets pulled out post-separation. And it shocks ordinary people that people would want to hurt their own children as well as their ex-partner. And we saw that like with the Hannah Clark murder and the loss of those beautiful children as well. Like, we're not talking about people of goodwill here. They are looking for every possible angle to inflict pain and continue the sorts of behaviours that were happening behind closed doors, now with the armoury that's provided by financial institutions, superannuation, government, insurers. So how aware of this issue are you, and how soon can we move to some outworking of that group that you've described? I mean, it's the first time, I think, that it's been gathered in this way. Is that correct?
I'd have to probably check to see if that kind of group has met previously. There has been regular engagement between ATO, Treasury Services Australia and DSS for some time, so it's not a new thing, but it is a significant body of work that organisations have agreed to, and the Child Support Stakeholder Consultation Group is one that's been re-established after a significant period where it wasn't operating. I think in terms of that interaction between child support, financial abuse and family tax benefit, it is a really important issue that we are very aware of, that we know that while the system may work for the majority of families, there are circumstances where it can be used to impact both parents and children. That's why we are working through that review of compliance, and a lot of that also goes to a range of supports that Services Australia has to work with parents involved in the child support scheme and recipients of income support payments.
Can you put on the record how family tax benefit interacts with the child support and the ATO?
The child support scheme interaction with family tax benefit works in that a parent must seek child support to meet their obligations under maintenance action and maintenance income test, and that there can be reductions in the amount of payment that a person receives from their family tax benefit based on the amount that a former partner may declare in their income, or their efforts and activities to seek a child support payment.
Okay, so the active person in that scenario I've just described has to be the person who has fled the violence, the person predominantly who has the children, the person who has already suffered financial and potentially physical abuse, has to have the agency to do that at a time when they have probably limited agency and a lack of access to documentation, resources, and have been subject to kind of the behaviours that I've just put on the record. Clearly there's a system failure there. So can I take you to the safety by design principles that I know are operating in the public place with all the stakeholders that we've been talking about? What does a safety by design response to the intersection of family tax benefit with your agency, how does that look? What are you working on?
So I think, and perhaps I gave half of the answer before that might go to that, in that there are a range of exemptions from those maintenance action test and maintenance income tests, which allows that personal circumstance of an individual, including for violence or fear of violence, to ensure that a person is not required to meet those, and they will be paid the full rate of family tax benefit. So if that
So what
person...
if you haven't got a fear of violence, you've just got a fear of continuing ongoing harassment of the kinds that I spoke about before? Does it have to be fear of violence?
I might seek to...
I'd say it's a definitional point there, so Kirsty Fashni. Of course, we say family and domestic violence. It's not necessarily has to be violence. It can be psychological, it can be financial abuse, it can be a whole range of ones. So the definition, while we might say violence, we are talking more broadly as to what is an abusive approach.
So if somebody contacts you, let's assume they have sufficient agency, despite everything that's going on, to get on the phone, do the thing, or make an appointment and come and have a conversation with you. And they meet, the good people at Services Australia who are there to help. What it was described a little bit as magic words is what's required to get the banks to respond. What magic words do women have to use? Because we've heard evidence of people coming to the government and saying, he's hidden the money, he's cut me off from the bank. I'm homeless now. The house was sold to his mate. The accountant who used to look after both is providing me with no information. When they say things like that, they are not, by report, they are not getting a response that would be triggered if they more clearly said, I'm in fear of violence. That is the evidence we are receiving, that the system isn't responsive enough to the full range of forms of abuse that are operationalised by our current legal system, our current financial system, our current insurance structures and our current superannuation. Can you reassure me that you're hearing them?
We can talk to it from what Services Australia does, because we do train all our staff to listen and attempt to understand if a person is experiencing some kind of vulnerability. Jodie, you have... I'll pass to Ms Robinson.
Yeah. So when a customer makes contact with child support, for example, we have various points in time where we have what we call our risk identification and referral model that's activated. And these are requirements, so it's a question that our staff will ask, and it's simply along the lines of, are you or is anyone else concerned for your safety? And if a customer at that point in time indicates yes to that, then we have what's called a family support team. And in the child support space, it means that we will automatically refer customers to that family support team, who are our specialist team within child support for responding to people experiencing family and domestic violence.
So is the question asked exactly as you described it? Are you concerned for your safety? Because there's a physical dimension of that's implied in that question that doesn't appear to be capturing, are you concerned that all the money that you had with your husband is disappearing? Are you concerned that your husband's about to take over? Like, you can't ask all of those questions, but there's a physical orientation in the way that question you just put on the record would lead people to, they have to be under threat of physical violence before they can activate.
Yes, and I think we've had some learnings along the way. So the question used to be quite specific in those terms.
Yep.
Are you or anyone else concerned for your safety? But over time, what we've done is refined it so that staff can tailor that question to the circumstances that are being presented. So if somebody is talking about, for example, my ex-partner isn't meeting his child support obligations, and of course we can see that from the information available to us, or that he's hiding funds, hiding assets, then the staff are equipped to ask that question in a slightly different way. Do you believe he's deliberately hiding assets? Do you believe he's deliberately hiding income? Anything like that, and then that also will trigger that referral to that same family support team. Okay. So the training that we provide to all of our service delivery staff, which is our mandatory family and domestic violence training for all service officers, covers a very broad definition of family and domestic violence. It certainly doesn't have a focus on physical safety, and on physical violence it covers all of the aspects and how that might present when a customer is engaging with our services. And then once the family support team are working with the customer, then they will talk through with them the full range of options that might be available, like an exemption from claiming child support that Mr Peoples referred to, and then also work with them to ensure that they've got appropriate supports. Many people already do have appropriate supports established in the community, but where that's not in place, then we have our social work services embedded within our family support team. And so they can provide support to customers as well, which also includes risk and safety assessments if someone's concerned about the continued perpetration of the violence in whatever form that presents.
There's so much to discuss here, and I have many more questions. I expect I'll have to put a lot of them on notice, I'm afraid, because I need to share the call with my colleagues. And I am heartened by that sense of a more sophisticated and nuanced response. But I remain concerned, based on the evidence we had, that the family benefits tax response is still not adequately responding to increased, what I'm assuming would be increased notifications and growing awareness, because that doesn't accord with the evidence that we've received. So I just put that on the record. And perhaps there can be some further investigation of that. And if you could provide some data to the committee on what the ATO data reveals, and we'll have them soon, around failure to lodge tax returns, deliberate misrepresentation on tax returns, consequences for accountants who enable that whole ecosystem that you intersect with. Because that is connected to you. I know you're separate entities, but there's a profound connection, certainly in the life of ordinary people, and most profoundly in those fleeing violence or seeking a point of separation at which violence then escalates. So I will have questions on notice, but I'm going to go to Senator Pratt, and then I'll come to Ms Mascarenhas.
Thank you, Chair. Can I ask, please, in the context of enduring power of attorney, but also the Department of Social Services having people who are an authorised representative, can you give us some examples of the kind of abuse that can occur when someone is your authorised representative, and what you do to go about preventing it?
Nope. They're all looking at each other.
Senator.
No, Ms Lutz.
Yeah, thank you. Anna Lutz, Group Manager Ending Gender-Based Violence. Senator, I don't think we've got that detail specifically on that issue with us, so we'd take that on notice.
Okay, so we have had some examples come up in the course of the inquiry, which included, for example, a daughter stealing all of her mother's social security, having put herself in place as the authorised representative. Clearly also we've seen other forms of elder abuse where, that can take place either with someone making deductions out of their bank account, but equally it can also happen more directly in terms of misrepresentation to the Department of Human Services. And so I'd really appreciate, I guess, if you could give us some examples and what you do to prevent them. False reporting of income has also come up as a form of financial abuse, where someone has been forced to underreport their income in order to inflate their social security. That's resulted in them getting social security debt. Are you aware of any of those kinds of examples?
Senator Ben Peoples from Participation and Family Payments Group. Yes, we're aware of those. That's something that we work with a range of stakeholder groups to consider and have looked at a range of arrangements within the debt management provisions, including to ensure that special circumstances can be considered in those circumstances, and that we can look at waiving debts or managing those debts to reflect those specific circumstances. And so that's definitely something that we're aware of and work really closely with Services Australia to ensure we can minimise the impact and support people in that circumstance.
Thank you. And look, other forms of financial abuse might include grandparents rearing grandchildren but not being in receipt of family payments for those children because they're in fear of the consequences if those payments are removed from the parents of the children. Can you give us some other examples of the kind of abuse that can occur with the receipt of family payments?
So I think there's a range of ways that a perpetrator can use reporting arrangements within the Social Security and Family Payment Scheme, which we are aware of and monitor and work closely with Services Australia to manage. These, I think you've referred to a few where, including...
I guess I'm really keen to see that you can give us case examples, can see the actual dynamics of what's happening.
Yeah, obviously I can't go into any specific cases. Perhaps we can look to provide some cameos or things like that to the committee. We see it in both income reporting, asset tests, reporting of member of a couple, under-reporting of income in the child support scheme, the regular changing of income in the child support scheme, as well as through, and our Services Australia colleagues may be able to talk to this more, things like communication, reporting arrangements where government services are contacting individuals and change of address and things like that.
Senator Tony Piazza from Services Australia. I suppose another example would be the non-lodgement of tax returns in terms of child support.
Yes.
And I know that's been obviously reported as well. So we do have a program where we do identify customers that haven't lodged at least once in the last 5 years. We then as well work with ATO in what's referred to as the lodgement enforcement program. So we do recognise that and we do take actions where it's identified.
Can I ask a question?
Thank you.
Why is it every 5 years? That's just standard operating practice. Is for any good reason?
I'd have to look at,
because my question is,
background
at the moment of a point of separation, is there any reason why that wouldn't automatically trigger an engagement with the ATO to say you need to get a tax return in from this person now? Is there any impediment to such an action? Because you're the first ones to find out about separation. ATO is a long way behind. Would there be a problem with that sort of a notification?
I think we'd have to have it, from our perspective, we'd have to see what was possible in terms of being able to identify it and then as well being able to share that information if we're able to.
Because you are going to have people who have to engage in the child support scheme. That becomes pretty obvious pretty quick. People, I've got to feed my kids, they contact you, right? But we know that people are being coaxed into the child support scheme even when exemptions may be available on the basis of family violence. We know that they're urged to collect payments privately, so the state administrative costs are reduced, and we know that they're ushered into the family payment calculation system that best minimises government family tax benefit Part A. Okay, so all that's going on, which needs correction clearly. If that can go on, why can't the minute you know that somebody's separating and they're seeking family support, that there's a notification immediately to the ATO that says
this is a partner relationship. You need to get the details from this person now. They need to lodge. Is there an impediment to that because of privacy or security concerns?
I think I'd have to...
Can you take that on notice?
Look at that.
And similarly, at that same moment, is there currently a pathway or an impediment to a declaration from all of the banks where monies might be held that relate to each one of the partners for a declaration of that to be made? Is there any does that happen, or is there an impediment to that happening? Can you take it on notice? Because it seems to me these are two critical problems that have been talked about for a really long time. Back as far as 2005, compliance programs have been introduced, according to this data. But the proportion of payers who've not lodged tax returns and proportion of parents with liabilities less than $500 per annum have remained steady over the last 5 years and are currently measured at 22% and 28% respectively. That's a sign it's not working. Something's seriously broken there. So can you think about recommendations that this committee can make of that kind of practical nature? And if there are impediments to such, moments to turn on some protection for these women and children against men of the character whose behaviours I've described here this afternoon. Because they're not playing nice. They're looking for bullets to shoot post-separation, financially, and ultimately, perhaps, in the case of Hannah, the first incident of domestic violence was her demise. So that's what I want you to think about in terms of interaction with us. Back to you, Senator Pratt.
Thank you very much, Chair. Can I ask if it's possible to get and receive confidentially copy of the Department of Human Services manuals for dealing with clients identifying instances of family violence and financial abuse and their intersections? Or just a selection of those policies? But I do understand they need to be confidential, but I'd be very keen really to see how your capacity to respond to these issues at a face-to-face level with customers relates to the kinds of issues that have been presented to us by financial counsellors and community legal services.
Thanks, Senator. It's Kirsty Faciony again. Yes, I think as you are clearly aware, the reason we don't tend to spread these things around, because if perpetrators got hold of them, then they have even more weaponisation opportunities. Also happy, though, we'll see what we can provide and how, but also happy to offer a private briefing if you want to have a conversation around how we do those services and how the frontline staff have those interactions. I'm very happy to do that as well.
Okay, perhaps you could give us and how do you collect data on these issues as well in terms of their prevalence, and what data can you give us about that now?
Do we have much data with us?
Senator Tony Piazza, I don't know if we have any data with us at the moment. Our systems record data in different ways. So some of our systems have free text. Some of our systems might have an indicator, some may have a combination of both. But we're also limited under legislation, also privacy, in terms of how we can actually share that information across our systems. So we do have some limitations to if it's to what we can record, and obviously as well how we've recorded it.
Can you take on notice if you think that some of those legislative limitations limit you on actually monitoring the prevalence of financial abuse or not?
Happy to.
And if you can give us the data that you do have on its prevalence within the social services system. I noticed that your family violence payments, EVP programs paid in a number of ways in order to support people being able to use it without it being necessarily needing a bank account or and to be able to use it in a way that is not stigmatised, etc. I think one of the products is a Prezi card, and I think there are probably others. Have you looked at the extent to which you've got access to products that are widely available in the financial services or other financial services system to bypass, I guess, banking systems that could leave people vulnerable to abuse? And how do you deal with the fact that it can be the banks that are creating problems for people being able to access their government-provided payments because they haven't necessarily managed those issues properly? Thank you.
Great question, Senator Pratt. That'll be your last one, but
That's great.
they're not going anywhere because they're going to be joined by the suite of other departmental staff who are here. So there'll be another bite at the cherry, and then I'll go to you, Ms. Mascarenhas, for 15 to 20 minutes, and then we'll bring everybody else in together for the panel. Thank you. So
can I
answer that question for Senator Pratt if you can. Thank you, Ms. Toes.
Thank you. Thanks for your question, Senator Pratt. One of a key priority for the agency at the moment is to look at exactly what you've described, and that is being able to support people without a bank account being available to them or not being appropriate to use. So currently the agency has a physical card, which is an electronic benefit card essentially, and it's a kind of a cash card that we can give people who are in hardship. Give that to them, and it has some, it might have an urgent payment on there, for example, and some other support. We're actually looking at having a digital version of that as well, loaded into Apple or Google wallets, and that would be retained in the wallet and would be able to send money directly to a person in real time, essentially, to help them in that scenario. So no bank account needed, etc. So I think that is a really positive initiative. We're looking at rolling out this calendar year that technology. So
that sounds great. And I'm sorry to interrupt, Chair. I just want to ask the department to take on notice how that same technology could be applied for people who might want to stop, if you're vulnerable from elder abuse or whatever, that you actually do need to perhaps limit some of the transactions that can take place against the money that you're provided as well, and whether you're working on that kind of technology as well.
Yeah, it's something we're certainly looking at, Senator, as part of our a sort of a financial capability focus that we've got in the agency, and a big part of that is obviously around prevention, identification and supporting people who are victims of financial abuse. So we actually are doing a lot of work in that space to unpack all of the different issues and solutions. The first cab off the rank, as I've talked about, being that that digital card that we can get rapid support to people who are in real need of it quickly.
Thank you. Over to you, Ms. Mascarenhas.
Thank you, Chair. When we started this inquiry, we weren't necessarily anticipating the level of financial abuse in different areas. And the thing that I'd say that we've been surprised to see is that government systems are being weaponised to perpetrate financial abuse on victims. From a DSS or Services Australia perspective, have you guys gone through a process of understanding which parts of your services or products are perpetrating the most financial harm to victim survivors?
So Ben Peoples, Group Manager of Participation and Family Payments. In relation to the social security system, yes, we have commenced a process with Services Australia looking at a whole range of aspects of the social security system, how effective support is, gaps in support, and areas that can be used by perpetrators, partners and ex-partners to weaponise the system. So that is looking at the whole range of payments, how those payments interact together, eligibility and service delivery processes to identify where there are gaps or areas that policies don't align well and allow for that kind of weaponisation. And from that, we will be looking to bring forward ideas to address that. In relation to the child support scheme,
Before you answer that part, do you have a sense of the scale of the problem from, let's say, maybe a dollars perspective?
I don't have a sense of the scale in the dollars. We can look at what data we can provide. Obviously, you can look at things like number of crisis payment recipients, number of people who seek an exemption from the maintenance action test requirements under FTB to see some of the scale of the issues. But in terms of those gaps that may or points that may be used by perpetrators, we don't have a dollar value for that.
Thank you. I think you're going to answer a second part.
Yeah, sorry, yes. So in relation to the child support scheme, the government's made a number of significant commitments out of the family law inquiry, which are currently underway. Some of the more consultation elements, like the establishment of the stakeholder consultation group and the child support expert panel, but also a number of pieces of important research, things like a survey of separated parents, which will help inform some work we've got going on in the child support scheme, plus those reviews that I talked about earlier, including the review of compliance. We are progressing that work over the course of this year, and we'll look to then bring that together and undertake that audit of the child support scheme once we have that information, which will be critical to informing how we undertake that audit.
So one of the things that the Chair had talked about before was safety by design principles. And with the family tax benefit A, that's reduced even if child support is not paid. Is there a way that we can design the system so it is fairer to single parents and children?
I think that these are the issues that we're really keen to work through as part of these reviews, and we know that there are elements and arrangements that can be improved for particular cases to make sure that parents know the exemptions that they can apply for, to make sure that they know what payments are available, and to make sure that our policies are designed in a way that they can quickly and effectively get support to people that are needed. So I think those principles and how that payment will support particular people and their own circumstances are very much at the heart of what we're thinking about in this work.
So again, one of the statistics that the Chair shared was that 80% of mothers report that their exes have replaced physical abuse with financial abuse. And I understand that there are good processes in place from a Services Australia perspective. That statistic would suggest to me that a large number of people that are single parents that are having a reduction in their family tax benefit should be using the lifelines that exist within Services Australia. Do you have stats on the number of people that are accessing the supports that are there? And what my gut instinct is that there's an underrepresentation and that not all people recognise some of the supports that are available.
Ms Robinson? Oh no, Mr Piazza.
Thanks, Senator. We do have figures in terms of, for example, crisis payment. For example, between 1 July 23 and 31 March 24, we had a total of 66,351 payments granted for that.
Sorry, Mr. Piazza, could you say that number again?
66,351. I don't have here, how that correlates to previous years, and that's not till the end of the financial year. And of course, that's probably not a direct correlation either to programs such as child support or of that nature.
And I'm happy just to add to Mr. Piazza's answer, but in relation to referrals to support services, so specifically our social work services internally, of all the referrals responded to, referrals for family and domestic violence to social work services represent about 46% of all of those referrals. So in 2023-24, social workers responded to over 98,000 referrals to customers experiencing family and domestic violence.
Another question that I have is a quote that's taken from Women's Legal Services Australia, and they refer to an article which basically says that single mothers feel that the government takes a hands-off approach to fathers' administrative inaction. For single mothers, it feels like the government ignores the harm being caused by the manipulation of the system. Services Australia's limited investigatory powers and perceived inaction on debt collection has been identified in previous studies as a particular grievance for single mothers. I'm wondering if you have any comments in relation to that and whether there's been processes in place to try and rectify this issue.
Mr. Piazza?
Thanks, Senator. I don't know if I'm aware of those particular figures. I think we were speaking before, for example, in the child support space, where people minimise their tax return, fail to lodge tax returns. We're obviously aware of that, and we have, as we've talked previously, have procedures in place to report, for example, back, whether, if applicable, back to the ATO. But I mean, and I suppose I would. The position from the agency is that we're administering these payments and programs on behalf of other departments, essentially in line with the policy parameters and the legislation and what we're allowed to do. But where we can identify them and we have processes in place, we'll inform other entities, for example, the ATO of that.
Ms. Robinson.
Yes, I'm just happy to expand on that a little bit from a service delivery point of view. So there's a range of measures, particularly in relation to child support, that we do utilise. So the actions available to us include late payment penalties, deducting payment from wages and salaries, intercepting tax refunds. So at this time of year, there's quite an active program of intercepting tax refunds. So far, this financial year, we've intercepted about 78 million in tax refunds. Through that program, we can collect through third parties such as banks where we know that those funds exist. And then, of course, we can put in place departure prohibition orders and take, litigation. So there's a...
How many are in each of those categories you've just revealed?
Sorry.
How many people in each of those categories?
I'll probably need to take that on notice.
Please.
In terms of
Thank
coming
you.
back to you, back to the committee on that.
Thank you. And while I've got the call myself, can I ask you that 98,000 referrals to social workers, what data analysis have you done of what that reveals for the need for system change? Because clearly they're your people who are telling you what's not working. What's been done with that data?
So we utilise the experience of our social workers and the customers that they're servicing to provide real-life case examples up through the agency and to DSS to inform a broader understanding of the current experience of family and domestic violence, including where customers tell us, there's examples of the system being weaponised. So they are one source of quite rich data that we utilise to inform
so if you
our
could,
program
on notice,
design.
provide more about that.
Yep.
Like, that's 88,000 Australians who were in such need that they had to get referred through the department to social supports through a social worker. They will be able to tell you what's not working, and I'd be interested to know of any academic research that is using that data de-identified to help discern best policy responses as well. Back to you, Ms Mascarenhas.
Thank you. This question is about culturally and linguistically diverse clients. And so if you've got any statistics on victim survivors that have come through your doors, I would be interested to understand that. But the second part to the question is we heard from one of the financial counselling organisations over here in WA, and they were talking about their cold clients, and they had said in their witness hearing that that often you can tell that clients that English is not their first language, but they are not offered an interpreters. Interpreters are hard to come by and they're expensive. DSS stopped funding interpreters for us. We now have to pay for our own, which doesn't help with financial counselling or even trying to get one. I'm wondering if you could provide a bit more context in relation to that comment, and is there a way that we could get more interpreters available to assist with financial counselling but also financial abuse?
Senator Patrick Burford, Group Manager of Communities. I could certainly take on notice the history of that statement or that commentary from the financial counsellor. We fund the financial counsellors to the tune of about $50 million per year, including a national debt helpline, and also afford those financial counsellors a fair bit of flexibility in how to best service their clients. So I'd have to find out about whether that does include flexibilities in terms of getting interpreters in. We're also working with industry, from banks to insurance sector to water and utilities, for an industry funding model that's committed another 11 to 12 million per annum, which will see another 30,000 Australians access financial counselling. So in terms of their investment in their training to work with a wide range of clients, specialist supports for certain groups and certain financial issues, we've got elements of there. I could provide a bit more detail on notice as well. But to your particular question about the history of funding for specific interpreters versus what the flexibilities are currently, I'll take that on notice and get you a bit more detail.
Thank you. This is my final question, and when I think about this issue, who I'm thinking about are children of single parent families and single mums and dads. And so there's, I think, 83% are single mums, 17% single dads. What's the advice that Services Australia or DSS has to help support these people that are experiencing financial abuse? I sense that we're in the process of changing the system, but for someone that is going through a really tough separation, or they've already done the separation and they continue to be financially abused, what's the best advice that you could give these single parents?
So I would say, it's Kirsty Facian here from Services Australia. I would say if they're dealing with this agency, then they should be open and let us know so that we can support them to the best of our ability. If they're not comfortable in dealing with our agency, there are some of those other advocacy groups out there that we are very closely engaged with on both sides, whether it's lone fathers or single mothers. They can go through those to have the conversation to say what support, and we'll work directly with those advocates as well. They're probably the main ones. They just need to be open and let us know. Like, the staff will do their best, and we also understand that's sometimes quite a challenge.
Thank you. The maintenance action test, based on data from the Department of Social Services, reported in this article, the weaponisation of child support in Australia, asserts that 85% of the parents passed the maintenance action test, including 14% of those who were exempt and 1% whose outcome was pending. Then it goes on to describe that those who fail the MAT are likely to be vulnerable women, experiencing violence, women with low literacy, culturally and linguistically diverse and Indigenous women. And it says, rather than having an acceptable number of women failing the MATs, children in such families should be supported to receive their full child support and financial tax benefit A entitlements. Is that something that is underway or being considered, Mr Peoples?
So as part of the range of work that the department is undertaking in response to that family law inquiry, one is in relation to the interactions between FTB and child support. It's something we work very closely with Services Australia on, and it's something that we look at really closely. We know that those MAT exemptions, the majority of those are for fear of violence, with around 60% of the MAT exemptions being in that circumstance, and so that that's over 100,000 children who have parents who have applied for that MAT exemption. So it is a very significant population, and it's something that we are keen to ensure both kind of the service delivery and the policy is working.
Including making their parents pay an adequate amount of money so that the cost transfer, this is a form of financial abuse that's it's certainly being felt and impacting the former partner and the children. But it's a cost to the public purse by, smart aleck men who think that they can get away with this. And they seem to be getting away with this. And all of the taxpayers who want great things in their community to build community are not getting the money because people who think they're too good to pay for their children are gaming the system.
And I think that is then why that work that we're doing with ATO is so important, so that people meet their obligations to lodge tax returns. So, and I think that's a really important point, that regardless of kind of the status of an individual in that relationship, they are required to lodge a tax return each year. And so that work we do with ATO and Services Australia to make sure people are meeting their tax lodgement requirements under legislation happens and does enable then Services Australia to administer the scheme in the way that it's designed.
Okay. My last question is, do you have any interaction with the legal profession directly? And are you ever made aware of lawyers who are basically hired guns? Because this is what I'm certainly hearing. I'm certainly hearing it in cases that have been brought to me as a senator and in community, that it's mate, not happy with the separation. I can tell you where to go. This is the person you go to, so you can really hurt them, right? Those conversations are actually happening, shamefully, are happening in our community, and people in the legal profession are facilitating that kind of abusive behaviour in our court system, right? And I'm not interested in us having to continue to clean up the mess of all these people everywhere who are making money literally out of the misery and the abuse of our Australian citizens. That shouldn't be a cost that continues to fall to the public purse. As much as we need to support people when they need the support, there are system failures that involve the legal system. Outside of what the Attorney-General is responsible for, outside of the law, there are fundamental professional responsibilities that are not being adhered to. What interaction have you got with the law societies and the legal practitioner bodies that are there to ensure that lawyers are not weaponised and that they're actually operating to the standards that are required of them as professionals?
So it's Kirsty Fashioney. I'd say For Services Australia, we don't deal directly with those agencies. And I know we've got Attorney Generals coming up and they can probably speak to some of that. We do have a close relationship with the advocates at other legal aid side. So we hear from them, and in fact they are closely engaged.
Yeah, they're sort of the David in the David-Goliath battle, though, aren't they?
Right,
so who's talking to Goliath's army who are raking the money in and exploiting the Australian taxpayer, damaging women and children, and perpetuating abuse for their own personal gain? Who's talking to them?
I'd say for the regulation of the legal industry, you'll probably have to raise that with Attorney Generals.
We did raise it with them, and I asked them for details about who's been sanctioned and what sort of sanctions have been embedded, because this is like an industry. We're talking, tens of thousands of people per annum. So, sorry, I'm not angry with you, but I am becoming increasingly angry that there are people who are moving around in our society who are not only emboldened to do this, but bragging about doing it. Like it's just immoral and profoundly damaging. And it's certainly, the burden is a terrible thing to see for people personally, as well as, the financial implications more broadly. So thank you very much for the evidence that you've given us independently today. Don't go anywhere, because
make space.
We're going to ask you for phase 2 of this afternoon's conversation, just to stay there. And given the nature of the space here, I might invite... before I move on to that, there will be questions on notice. Could you provide the responses to those, if possible, by the 11th of October? And I welcome representatives of the Department of Social Services Australia, Australian Taxation Office, and the Attorney General's Department to come forward. So we've got a few spots for you on either side. So let's go into round table mode, basically.
Oh, yes, please. Thank you. Yeah, make the claim.
Okay, good. Can we do estimates?
Yeah, just making sure they don't have to do anything special.
Ready? Great.
Thank you.
Thank you. Thank you very much. Welcome to representatives of the Department of Social Services, Services Australia, Australian Taxation Office, and the Attorney General's Department. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today? We might start with you, Ms Miller.
Thank you, Ms Claire Miller from the ATO, Deputy Commissioner.
We'll just hold on for a second because we haven't quite got the volume. Let's have a go. Oh, you won't need to get closer. They should pick you up.
Okay, Claire Miller, ATO, Deputy Commissioner, Digital Delivery Services.
Thank you.
Farisha Ali, I'm an Assistant Commissioner in Law, Design and Practice, looking after objections and review.
Anita Challen, Assistant Commissioner of Frontline Operations in the ATO.
Robert Thompson, Assistant Commissioner, Individuals and Intermediaries within our Client Engagement Group for the ATO.
Thank you. And we'll go again, Ms Robinson.
Jodie Robinson, General Manager, Child Support and Tailored Services, Services Australia.
Tony Piazza, Services Australia, General Manager, Families, Indigenous and Tailored Programs.
Kathy Toes, General Manager, Working Age and Pensions Program Division, Services Australia.
Kirsty Vaishni, Deputy CEO, Program Design Group, Services Australia.
Patrick Burford, Group Manager of Communities in Department of Social Services.
Ben Peoples, Group Manager, Participation and Family Payments in Department of Social Services.
Anna Lutz, Group Manager, Ending Gender-Based Violence in Department of Social Services.
We can't hear Ms Lutz. Would you be able to increase the volume on that mic? Would you say your name again, please?
Anna Lutz, Group Manager, Ending Gender-Based Violence, Department of Social Services.
Thank you very much.
Virginia J, Acting Assistant Secretary of the Privacy Reform Task Force.
Celeste Moran, First Assistant Secretary, Integrity Frameworks Division from the Attorney General's Department.
And Rebecca Mills, Acting Assistant Secretary, Family Law Branch of the Attorney General's Department.
Samantha Bing, Assistant Secretary, Family and Community Safety Branch.
Wonderful. Thank you all for being here. And, you know, given the nature of the task force where you're working together and drawing in other entities to inform your work in light of the National Plan to End Violence, it's great to actually have you here to ask questions, so we start to get the threads pulled together for our purposes as we draw to a close this inquiry. We're nearly at the end of our inquiries, and hopefully we've raised community awareness in the course of it. Just to help, because there's so many of you, can I just get you to indicate when you think you're going to be able to give us a good response, and I'll call you so that Ms Mascarenhas and Senator Pratt and Mr Hawke will know who's answering. I'll name you before you give your answer. Do we have any opening statements from Attorney Generals or from the ATO? No. Okay, we'll go straight to questions then, and I'll go to you, Ms Mascarenhas.
Thank you, Chair. We've uncovered quite a significant issue, and I think we've been surprised at how pervasive this is. We don't have enough data when it comes to tracking financial abuse. Do you have a view on how we collect data ethically without infringing on the rights of privacy?
Who would like to answer that question? Okay, Ms Challen.
Anita Challen, Australian Taxation Office. I think from our perspective, the collation of data is largely restricted within the ATO to the necessary requirements to support the delivery of the tax legislation. I think in terms of being able to identify one of the challenges that we definitely face, particularly in determining instances such as financial abuse and coercion and broader sort of vulnerable circumstances that taxpayers are facing, is the ability for our staff to be best positioned to actually identify that in the first instance. We're also quite mindful of how that may otherwise present if, for example, incorporated into their general information and account, whilst there may be some benefits to being able to identify that so that we can otherwise take those things into consideration into future interactions. It may actually present for a longer term implication that may not necessarily exist where it's a more immediate circumstance that they're facing. So I'm not sure that I have all the answers to the question that you've asked, but certainly it's something that we'd be willing to work with others to understand how that might be done in a more ethical and sustainable way, because so far I think we have largely found that quite challenging, but also, as I mentioned, perhaps a little restrictive in terms of what we are able to identify and then report on and subsequently share for the benefit of how we could deliver more joined-up services.
So one of the areas where we've seen a significant level of financial abuse, it has been around child support payments, and so it's been indicated that that's in the order of $1.7 billion. And I'd say that each departments have different strengths and weaknesses. From a principal's perspective, which department is the best at collecting money effectively? And I ask this from the perspective of, I want to think about safety by design and also making sure that single-parent families and children are getting the money that they deserve.
All I can say is Kirsty Faishny.
Ms Fakeney from Services Australia.
Apologies. So, yes, Kirsty Faishny, Services Australia. So we're expert at giving money out, is what I would say. So we give around 86% of all government funds going out. The collection coming in is primarily taken by the taxation office because it's a tax-based system that we're in. I was just going to also reflect on your earlier question as well, because I think it's actually quite important, the legislative framework, because we all live it every day. We have very strong engagement with the Australian Taxation Office for the purposes of child support, and the legislation goes specifically to that. Outside of that, no, we can't do certain things. Same thing, and I mentioned it at the last hearing, within Services Australia, because we are bound under several pieces of legislation, including the Health Insurance Act, the Social Security Act, and the Child Support Act. Those acts in and of themselves also have privacy and secrecy provisions that prevent us from sharing the data across them. So we struggle to get a single view of an individual that might provide us with broader insights into what's going on, because we cannot literally share with ourselves information about a single customer across those master programs.
Mr. Thornton, is it?
Sorry, Chair.
Mr. Thompson, sorry, yes.
Robert Thompson, Australian Tax Office. I don't know that we'd make a view that perhaps one agency should collect all the debts across a number of different acts, given we all have different responsibilities to administer different parts of different laws. What I'd say is I think there's an element here about us thinking about how we can better exchange information, noting some of the limitations we currently have, or we can work closer together, both on the identification when people might be experiencing vulnerability, including financial abuse, and how we can better do that to make sure that everyone has the information they need to both identify when someone is potentially vulnerable, and then treat them appropriately, including when they need to collect debts from those people.
Can I ask a question here about your intersection with the banks? I mean, we give banks a tax file number. I want to go to the question that I asked earlier of Services Australia and DSS. If at the point of separation there is a notification to DSS that the separation has occurred, do you have the capacity to immediately identify or request information from the banks about where assets are? Because this seems to be the first part of the game that gets played, hiding the money, withdrawing access, retreating into the blindness of a lack of communication to create new weaponry post-separation. What capacities do you have, Mr. Thompson?
So, specifically with respect to what we can exchange with banks, I might need to take that on notice, but I can probably generally say that the ATO we only disclose information where we think it's both legally and ethically correct to do so, and we are quite, we do operate in the bounds of Division 355, which is about protecting taxpayer information, and so unless that is normally in carrying out the duties under the tax acts we administer, then we need to rely on one of the exceptions. I need to take on notice as to if those exceptions would allow us to exchange information with the banks in that way. We do receive a lot of information from banks with respect to how much interest income. We also, as part of our general audit procedures, also receive a lot of information from other sources to try and identify unexplained wealth, which might go to that point you were talking before about people not disclosing their income on their tax return. But specifically on the point around what we could share in that situation, we'd need to take it on notice. However, it may also be a question for government because it might be a
privacy is a critical part of the effective functioning of the taxation system, and it matters to people that their matters are kept private. So we don't want to play with that at all. But at the moment of separation, we know that there is a problem that is growing in impact in our community. We know that social services is picking that up. Services Australia is picking that up probably quite quickly. And for hopefully the majority of people, the system isn't gamed, and that people have authentic care for their children and respect for their partner, and it's going quite well. But if a notification was sent from DSS to ATO, there's been a separation. If everything's working well, no further engagement required. But the minute there's a signal there's a problem, which might involve family law as well, there can be an activation of a degree of visibility by the ATO that could be triggered. That I would say, where the privacy, the benefit of the privacy protections are lost by the individual who is failing to provide for their own, or failing to not abuse their former spouse and provide for their children. Have you enacted anything like those sorts of responses when you've been given egregious cases by Services Australia?
Senator Anita Challen from the ATO. I'm not sure at the moment that that is the nature of the interactions we have from Services Australia. So we certainly do work with referrals, particularly in the child support area, as was mentioned previously. The referrals as they present through the lodgement enforcement program that we undertake are largely in regards to lack of lodgement of income tax returns.
How many do you get per annum, Ms Challen?
So it does vary per year. I do have the numbers here of how many we received last financial year, which I can share.
And maybe you'll notice over the last 5 years that'll give us sort of a sense of ups and downs, because we've had a bit of a shock to the economy during COVID that does change things.
Yes, certainly. So what I can say, Senator, is that in 2018-19 the referred population was 230,000 cases. In 23-24 financial year, the number of cases has reduced, and it was down to 161,997 in the last financial year. As I understand it, some of that is in terms of refining the nature of the population to ensure that we do get those that we can actually take action on. There are some that we can't undertake lodgement actions on account of available information at all to contact the taxpayer. And of course there are instances where they're...
So they're hiding from the ATO?
I'd say they'd be unavailable to all agencies, hence the referral in the first instance, but yes, including the ATO, potentially.
So unavailable to all agencies. So this is people just moving around in our polity, unknown to any agency.
Well, and sorry, Senator, I probably shouldn't suggest it is definitely all agencies. Certainly the information that we have available to us is limited, and I've probably made an assumption that it would be limited in other agencies as well.
And what would you need to be able to get the information to fill in those gaps for the missing people?
Certainly we'd need to be able to contact them. They may not be in the country. There'd be a range of situations that would present.
But
I don't
you would have
a complete
their
list.
movement in and out of the country through other agencies. You'd have their bank details if they're still banking.
If they're still banking.
Yeah.
Yes.
Do you access that? Can you access that, or are there restrictions on you accessing their banking behaviours?
I'd have to take on notice all of the opportunities that we have to investigate the information, but certainly there are opportunities for us to do some investigations.
And driver's licences for freedom of movement? Can you search that data? Can you find out?
I'd need to take that on. I think we would have quite a range of opportunities to get information on people. We are somewhat limited in how we can just generally use available information, so it does need to be provided to us in the context of being able to use it for our purposes.
So the trigger is you have a partner who is not being paid, and you have children who you're not supporting. Is that not sufficient trigger, is the question? What do we need to do to make that a trigger for you to be able to get this information that is resting in the ecosystem somewhere of this digital world that we operate in?
Yeah, certainly there would be, as I said, limitations with regards to the use of information for the purpose of...
privacy.
Exactly.
Right. So this is an interesting conversation. This committee's looked at the Tax Practitioner Board and the ATO and the inability of sharing of information that was critical, and the government's already undertaken action to correct that. Sounds like there might be some correction needed here as well. Back to you, Ms Mascarenhas.
Thank you. This is a question around our tax system, and one of the common themes that we hear is of couples that are separated. Typically, victim survivor is a woman. Typically, the perpetrator is a male. Some of the cases that we hear from a child support payments perspective is that some perpetrators are restructuring their financial affairs through maybe small businesses, which results in them having little or no income but yet they have expensive cars, expensive holidays, expensive houses. And so you see this disparity within a family unit where a child who might spend time between two different households experiences a household that's living in poverty versus one that's living in significant comfort, if not luxury. How do we, this seems to be a theme that keeps on coming up. Is this something that the ATO is aware of? Is there a way that we could tackle this to make sure that children are experiencing equitable circumstances in both the households where they're living?
So some of that might be a question for government around policy changes, which would have to direct to Treasury. What I can say is, though, we do exchange a number of data sets with Services Australia when it comes to the Child Support Act. So that can be an exchange with respect to them determining a child support assessment. That can be with respect to them identifying details to be able to pursue a debt, and that can also be information that then allows them to understand or tell us to garnish or withhold someone's tax refund. That includes a number of possible data sets, including STP data, which I think we've talked about before, single touch payroll data, but also other data sets where those people might be running a small business. Exactly how they use that data is probably best a question for Services Australia, but we do continue to exchange a number of data sets with Services Australia as it relates to those elements for the Child Support Act. What I'd add there as well is we do also have a number of working groups at both a Band 2, a Band 1 and a Director EL level, working with Services Australia on data exchanges. And to the extent that Services Australia is looking at a potential new use model for any data set that we might exchange with them, they do engage with us on that as well.
Ms Mascarenas, can I just interrupt you, because Senator Pratt is going to stand in for one of our colleagues at a public event. Just want to give her a chance to ask a couple of questions before she has to depart. I'll come back to you. Senator Pratt.
Thank you. Can I ask how close are we to having model power of attorney laws? I know it's been given priority status and I know there's been some discussion, but we'd really like to see that accelerated, and I wonder whether there's any new information about what those laws should look like that we've accessed as a committee that very much need to inform that so we can get it done more quickly.
Samantha Bing, Attorney General's Department. I'm not able to give you a precise timetable for the reform program in this space. I can say that a very comprehensive consultation paper was released last year. We provided information to you about that in the context of our written submission. We continue to have discussions with our state and territory colleagues on the analysis of that work, and we will be providing an update to the Standing Council of Attorney General when they meet later this year about the next steps in this space.
We did have good evidence from the Law Council of Australia this morning that would be of interest to you, I think, as well.
Yes,
I don't know if you were
absolutely.
Listening.
Yep,
Thank you.
we
were you listening?
certainly were. Yes, the branch was listening to that this morning.
Thank you, Senator Pratt.
Can you take on notice if states are too slow to respond to that? I guess I'm keen to see banks be able to take more responsibility for how we can, I guess, support the enforcement of, because it's illegal to use your power of attorney over someone else in an improper way, but it seems to be rife. So I guess I'm also wondering the extent to which we could get ASIC or APRA, or, sorry, not APRA, AFCA, to make sure they've got the right powers to intervene when and if it's taking too long to get the laws that we need fixed.
Happy to take that question on notice. I think there are a range of conversations that occur with the financial institutions in this space. And I would also note that there's a range of financial elder abuse that occurs irrespective of whether there's an EPO in place. And each jurisdiction would have different arrangements in place for how those complaints are dealt with and responded to, including the method by which a financial institution can make those referrals as well.
Can I just ask a question, Ms Bing? Would it assist you if the banks were actually able to see what's happening with transactions going into other banks, not just within their own bank? There's some privacy issues around this as well, but that seems to be a containment on banks to be able to rectify identified fraudulent removal of funds, whether it's by power of attorney or simply by opportunity.
I would only suggest that enhanced information sharing between systems, platforms, institutions is always beneficial in combating all kinds of forms of abuse. Yep.
Senator Pratt.
Thank you. Can I ask what consultation is happening with the Department of Social Security or Human Services around enduring power of attorney, because they have similar issues arise when someone becomes a signatory to someone else's social security account with or without an enduring power of attorney. And I wonder the extent to which better innovation, sometimes even in the oversight of the banking products that are available, would enable better surveillance of people's banking without it totally being handed over to someone else. And I know that's a rather complicated question, so I'm happy to leave that one on notice as well. And to also take on notice, because this is a policy question, I would really like to see leadership on financial abuse. We've got the ACCC, we've got ASIC, we've got AFCA that does some work on financial abuse, but it really says that it needs a code of conduct in the same way they have for banking services, that they need one for financial abuse in order to better do their work, about whether there are other agencies. So it's good to see the ATO, DSS, AGs here. But in the context of family violence as a whole and getting a really strong government response, I would really also like to see the ACCC and ASIC, for example, around the table today, because they can help prevent abuse between consumers if they had the right powers and the right commissioners mandated to do so.
Do you have a view on that, Ms Bing?
Thanks very much. Look, I really would need to look at that.
It is a policy question.
Policy question more closely.
And I'm sure that all of you may have a view. So that's a question on notice from Senator Pratt.
Yeah, and I guess I would like to see that put up through the department to the ministers, noting that it is a policy question, so that, you know, we can work on our recommendations in that context.
Thank you. Happy to take that.
Thank you.
Thank you, Chair.
Back to you, Ms. Thank you, Senator Pratt. Thanks for your questions today, and good luck with the ensuing activities. Back to you, Ms. Mascarenhas.
Thank you, Chair. This was a question that I'd asked to the Law Council of Australia earlier, and it was in relation to perpetrators taking advantage of long delays in family law proceedings and doing that intentionally. I was wondering if the AGD is aware of any funding or processes which and I guess reforms of the Family Law Act that would prevent the family law matters that involve domestic violence from being used to continue to abuse victim survivors.
I'm happy to take that one. Thank you.
Yes, thank you, Ms Mills.
Thank you for the question, Senator. There are a number of measures that we have in the family law context to try to address financial abuse and misusing the systems to cause delays and to drain an asset pool. So from a range of education publications, there's law reform that's in effect and there's law reform under consideration and some programs. One particular one I would focus on in terms of the delays to family court matters is the priority property pools pathway. So that's a court pathway for small value property pools that the government has funded, and that enables the family law courts to provide a simplified pathway to assist separated couples to divide what are considered small property pools, so it's generally under $500,000, to more quickly get that through the court processes and do that in a more cost-effective way so that you're not draining the assets and that you minimise those risks and legal costs and the potential re-traumatisation that can be associated with the process. So that involves a case management approach that's led by registrars at the beginning, where they can assist the separating couples to reach an agreement, and then a judge-led phase where there are simpler processes applied at a final hearing before a judge. So that program was expanded nationally to all filing registries across Australia in October 2023, and we understand that that's having a really positive impact in terms of significantly reducing the amount of time that those cases are taking in the courts in matters under that threshold. Then happy to talk about other law reform. So within the current family law amendment bill that's in the Parliament, there are some changes that are being proposed. So that's currently under consideration by the Senate Legal and Constitutional Affairs Committee for them to report by the 31st of October. So there are some measures in there that try to go to better supporting people in terms of the impacts of financial abuse. One is around elevating the requirement for disclosure to be in the legislation, on the face of the legislation, rather than being in the court rules. So it would amend that to just try to clarify and promote compliance with that duty of financial disclosure in family law proceedings, because we know that non-disclosure can be associated with financial abuse and systems abuse. So this just encourages that early and frank and full disclosure of parties' financial circumstances to try to minimise financial abuse.
Before you jump off that, how will that be observed? Who will that be registered with? And what are the consequences, proposed consequences, for failure to comply?
For failure, so there'd be, the courts would have a range of powers to impose consequences when a person fails to comply. So that it might include taking that failure into account when they're determining what orders would be just and equitable in property proceedings, or if that non-disclosure amounts to contempt of court, they could punish a person for contempt of court.
And do what to them?
It would generally be with a fine or a punishment along those lines.
And of what magnitude?
I would have to check that. I'm not sure on that.
Because I worry,
off the top of my head.
Given the profile of the people we're talking about, that it's just the cost of doing business, right? That they're so motivated to inflict pain and suffering post-separation that no amount of a fine is deterrent, especially if they run everything to the ground and then they've got no resources to pay anyway. So, too bad, so sad. That's the kind of perverse behaviour that I think we're seeing through people who want to perpetrate financial abuse. So is that going to be an adequate response?
I can look into that and come back to you on notice.
And who would this revelation of assets be delivered to? Just the court?
No, so that would be between the parties. So
okay. So think about a financial abuser. He says, if you think I'm going to tell you everything that I've got, you've got to be joking, right? And a woman who's been beaten down over years and is dealing with keeping, the kids at school and managing all of that without any housing security. it's a nice idea, but how's it going to work for a person who is a perpetrator of financial and domestic abuse?
It's one element. So another element that is a focus of the current bill is around better recognising the impacts of family violence in terms of the ability to make orders in
and that's the judge who would make those orders when the matter settles.
That's right.
In the meantime, what could happen with the ATO with regard to this? Like, if they can see things and if the banks can see everything, like, what are you guys doing to make sure that this actually gets revealed, even if there's a resistant person?
The court could have the ability to make interim orders to try to avoid the wastage or draining of assets. There is also a measure that...
But how quickly can they do that? I mean, this goes to the point of plenty of time by a person of malign intent to go and get advice from somebody in the legal profession or the accounting profession, supposed professionals, whose skills are then weaponised against the person who's already experiencing financial abuse. So, like, what's going on with using the things that we've got here so that these people can't get away with it before the person who has no resources and has to go to a legal aid and wait for their turn 3 years down the track? Right? It's all too late. So how's the immediacy of the need here being accommodated with the processes we already have in place?
The family courts do have a mechanism in place through the Lighthouse project.
Yes, which is the... Oh, no, that's the property pools. Sorry, go on, the Lighthouse one.
The Lighthouse project, which provides for risk screening and other case management support at the start of your application process. And depending on the risk screening arrangements, that may result in you being put in a different list.
So how long has that been in place?
The Lighthouse, it's a number of years now.
And how many people have been engaged in that? And what's the timeline between the moment of separation, when the abuse begins, and that process kicking in, getting to the Lighthouse? Or are they at sea away from the Lighthouse for a long time before they get to the Lighthouse?
Well, it depends when the parties are choosing to engage in the family law system, bearing in mind not everyone who is separating engages in the family law system.
Yep.
So I'd be able to share with you information from the court around the number of people who are going through that risk screening process.
So people who are able to manage it outside the family law system, we're going to make perhaps a false assumption, but hopeful assumption that most of those have kind of figured out a way to get through this before they have to go and engage with the law system. When they get to the law system, how many years down the track from the point of separation is that? Do we have that data?
I certainly don't have that data on me today.
No, would you mind taking that on notice?
I would have to see if there's been any research studies done on the
and is there any
point.
intersection between that knowledge and what the ATO knows about people in that interim period doing things like running down the business evidence that we've received, determinedly avoiding putting in a taxation return, financing their business into another shape or form? Is there any intersection between these things?
So, Senator, I can talk about what we can currently exchange with the court, if that's useful.
Thank you, yes.
So I know we've talked about our legislative requirements around secrecy before, and within those, in non-tax law disputes under our laws, we actually have limited ability to comply with subpoenas where it's a non-tax law dispute issue, including family law courts. However, there has been some changes to the law made so that we can provide information to the family law courts as it relates to any superannuation assets held by either individuals involved in the family law dispute. That's the current law. For us to be able to exchange anything else would be a question for government because it would obviously be a change in law.
Okay, probably a little more information on that process and, you know, what might need to occur to answer the sort of problems that we're putting before you, recommendations that the committee might give consideration to. Maybe there needs to be a piece of work about is it adequate for the needs, you know, like just, but if you can give us recommendations around that. Back to you, Ms Mascarenhas.
Thank you. The other area that I'm curious to understand is around joint property ownership, and so often this is treated unfairly for victim survivors, and sometimes perpetrators will use joint property ownership to inflict further harm. So, and particularly while waiting for affairs to be determined through the family court. Do you feel like the new amendments to the Family Law Amendment Bill, if that will better help support victims, survivors during proceedings?
Ms Mills?
It has the potential to. So I appreciate, I've listened in to some of the earlier hearings and understand there was a question raised around this, particularly in terms of if there was a repossession of a house in terms of someone not paying the mortgage whilst a victim survivor was living in the house. And we may not be able to prevent that in terms of the assets in the property pool being diminished, although there may be interim orders to try to preserve the pool, as I said, but we would need to look at the timeframes around when they normally come into place. But what the amendment bill does was it allows the Family Law Act to consider financial violence conduct, and so that includes financially abusive behaviours in a property settlement. So in terms of a party's ability to contribute to the property pool, as well as the impact on their future needs. So if, for example, a family home had been repossessed before final orders were made, a victim could ask the court to make an adjustment of the remaining property in their favour to account for that conduct.
Thank you for that. I'm going to switch to, sorry, I have a cold, I'm just going to cough briefly. I'm going to switch to superannuation law. And so we've heard evidence from multiple organisations about the need for superannuation law to be reformed, particularly from the perspective of when there's either a domestic violence relationship that results in domestic violence suicide. I also understand that the law is written from the perspective of if a perpetrator commits murder, they cannot receive superannuation benefit. But if it was manslaughter, then there's a way for perpetrators to get access to those superannuation funds. Does anyone here have particular views about the need for superannuation laws and the way that we can support victim survivors?
Ms Moran?
We're just looking at each other. We think this is one that is a matter for Treasury, unfortunately. I know that we've got the broader law reform, but superannuation is not in our remit. So we could, I suppose, take it on notice to see if Treasury can have a look at that for you.
Yeah, that'd be great. We can send it to Treasury as well, but the ATO, yes?
I was just going to suggest as well, APRA. APRA has responsibility for the supervision of super fund trustees with respect to making death benefits and ensuring that super funds are acting in the best interests of the superannuation fund members. So that might also be a question that needs to be posed to APRA.
Thank you.
This is probably my final question for now, and it relates to the enduring power of attorney laws. I know that we have a significant reform piece on the table, and we're in the process of working out a path forward for that. What I'm really conscious of is the fact that we have an ageing population. I think we've got $3.5 trillion worth of intergenerational transfer of wealth over the next 20 years. For elderly people right now, what would the advice be of maybe the AGD department on making sure that their money is protected? And I'm looking at this from two perspectives. One is we need to change the system, but people are currently being financially abused right now.
Thanks very much for your question. I just want to reiterate, of course, that the Commonwealth doesn't legislate in the enduring power of attorney space. So all actions that have to occur in this space in the example of EPOA laws that you mentioned are a matter for each jurisdiction, but the Commonwealth does have its leadership role in terms of the national plan to end the abuse of older Australians and its successor plan that's on foot at the moment, which we're working on closely with the states and territories. What we currently have in place is a range of Commonwealth-funded services that are available to support older people at risk of any form of abuse in this space. There's some really good resources out there. So compass.info, which has a range of over 800 Australian resources and details of over 300 service providers. That's actually getting around, that reaches over 400,000 people look at that website per month. It's got some really good statistics around its use. We fund a range of Commonwealth specialist elder abuse services that people can go to see. There's a 1-800 Elder Help number that people can also call, and they'll be referred through to state services who can assist them if they are vulnerable to abuse. And we also invite people to get in touch with Elder Abuse Action Australia, which is the peak body, and in fact they host compass.info. So there's a lot of education materials that are on foot at the moment. We've just released a national campaign, has been running recently as well, which you may have seen through mainstream and other services, including TV and the like, where we're trying to promote, we're trying to invite and give people information about where they can go to find more information. So there is existing national information and education out there, and that does include on enduring power of attorney and what each state has in place and what their laws and procedures are.
Thank you for that. I'm happy to share the call now, Chair.
Thank you very much, Ms Mascarenhas. And thank you all for being here. I just want to pick up on the elder abuse matter that you just were referring to there. I note in your submission, page 4, you referred to the National Elder Abuse Prevalence Study. Because this is a public hearing, it is an opportunity for information to get out into the public place and for media who are paying attention to really sort of help with this task. The prevalence study you report found that only 3 in 10 people who experience financial abuse sought help. And you make some comments here in your reportage of the prevalence study about the difference between sons and daughters with regard to elder abuse. So I just want to invite you, Ms Bing, to put on the record what is the nature and shape of elder abuse to the best of your knowledge at this point?
I think the prevalence study does give you that national picture, and it does talk to the many different forms of elder abuse that occur. Financial is one part only. There's a range of other abusive behaviours that have been uncovered in the work that's happened. And I'd just like to reiterate, whilst financial abuse is one component, it's really important to also focus on other forms of abuse which were indeed higher in their prevalence rate, so psychological abuse, neglect, which we do hear a lot of in this space. And the prevalence study did find adult children were the most likely to commit financial abuse, and sons were almost twice as likely as daughters to commit financial abuse. And so we did unpack a range of different behaviours that we're seeing there. What we're currently doing is we're commissioning some research to look at perpetration. So we've got a number of different research projects that have been commissioned under the auspices of the National Plan so that we can understand what is happening in society better. And one of those is on researching perpetrators and understanding more about who they are and what their perpetration patterns are. So there's lots of important research that has to be done to understand this, particularly, as you said, the ageing population we face.
Because it's sort of I really hadn't been thinking about it very much until just the last 48 hours about the potential intersectionality between younger men in intimate partner relationships honing their skills of financial abuse at an early part of their life, and then reaching a point where the perpetration of financial abuse on an elder then becomes very, very seductive a little further down the track. So they've spent the early part of their life getting ready to be even more enabling of their abuse, with elders. And I know Ms Mascarenhas talks about the transfer of wealth that's imminent, and that we've got potentially a huge honeypot of money acting as a very seductive point for the sorts of abuse behaviours that we've only seen really in the public place talked about so much with regard to women, abuse of men of their intimate partners. So how close do you think we are to getting the shape and form of those perpetrators, and how far are we advanced in understanding if the perpetrator of intimate partner violence, financial abuse, is a precursor or has a correlation with financial abuse of elders? Are the same people doing the whole lot?
I wouldn't be able to tell you what the answer to that is. I would suggest that, like other forms of violence, their intergenerational trauma can be a contributing factor. So you could have been a victim survivor as a child and you can grow up to be a perpetrator. Likewise, you can see scenarios where people evolve into this behaviour as they age as well. I don't think I can give you on notice the timetable for our research programs that we do have on foot that are elder abuse specific. Okay. There's obviously a lot of research that gets done across the board in the FDV space, which does also include looking at things like perpetration.
Wonderful, thank you. I'm going to work my way through some of the submissions in a moment, but I just want to go to the concern that I raised just before we opened up to the panel, which is about the failure to operate at a professional standard by people who are lawyers, and serious consequences for such people operating in a way that is seeing what's happening, are enabling what's happening in the family law courts. So what is your data, research, insight into the abuse of the family law courts and its proper management and treatment by the law society, the bodies of the legal profession, the state? What are the state ones that manage it all? What are they called?
Law societies.
It is the law societies who do it?
Yep. So the law societies in the states and territories are the bodies responsible.
They're adjudicated as well. You can tell I'm not a lawyer, right?
Or their equivalent are the responsible for their regulation.
Yes.
And consequences for legal practitioners and legal professionals that do not act in accordance with the rules or laws or expectations of that state and territory.
So what do you know about what's going on? And what's the action that you would recommend?
In terms of the prevalence of sort of misuse of the family law system to weaponise that against a party, that's not something that we have the information on. We do have information from the Lighthouse Project about the prevalence of family violence in family law matters, which is likely indicative of that there's significant financial abuse and systems abuse within it. So I think it indicates that in about 83% of matters within the Federal Circuit and Family Court of Australia, there's family violence risk.
Yeah, allegations of risk of family violence or child abuse.
Yep. But we don't at this stage have research that demonstrates the prevalence of misuse of the system. We do have some measures. So, for example, there was a measure in the Family Law Amendment Act 2023 that passed last year, which introduced a new overarching purpose of family law practice and procedure in the Act. And that has some provisions that require both parties and lawyers to try to resolve disputes in a way that ensures the safety of families and children, promotes the best interests of children, and facilitates the resolution of matters quickly, inexpensively and as efficiently as possible. And courts can make cost orders if parties and also their lawyers fail to comply with that obligation. In terms of,
have any lawyers had to pay fines for breaching that?
Not to my knowledge at this stage, but I can look into that on notice. And I don't know what the level of the cost consequences is, so I can also
if you can find out about that, you're starting to figure out exactly where I'm going to ask the next question.
And so can I clarify, Senator, were you asking about the prevalence of lawyers misusing the family law system? Is that where you're
for
starting
their own
premise?
financial benefit, like being weaponised by perpetrators who, and as I said before, that go into the local, community with some mates and say, who can I get to help me really hurt my partner on the way to this separation? Somebody who'll drag it out a really long time because I really want to inflict pain, and I want to hurt my children too. I mean, like.
And I guess that's an important distinction, that Ms Bing's made in terms of there are mechanisms we have that go to trying to ensure that the conduct of lawyers supports the objectives of the courts. But then there are also mechanisms that go to the question of individual parties trying to abuse another party through systems abuse.
Yes.
So, for example, another measure that went through in that piece of legislation was the introduction of a power to make harmful proceedings orders by the court.
And how many of them have been made?
We know that, I'm aware of at least 4. The legislation's only come into effect since the 6th of May.
Okay.
And so what they do is they're intended to try to protect parties from those harmful effects of protracted and adverse adversarial litigation. So what a judge can do is to restrain a party from repeatedly filing and serving new applications without first having to get the leave of the court if they've made an assessment that to do so would be harmful to the respondent, and then so they can then make it so you have to get the leave of the court before you would be able to do that again.
So we're probably a fair way down the track of people having been enabled. I guess I can ask you all now, in terms of creating a protective mechanism of a unified government, carefully shared information that doesn't compromise people's secrecy and privacy, what do you need to be able to tell one another? And when do your various responsibilities have to be triggered to create a fence at the top of the cliff rather than a current response as an ambulance at the bottom of it? What do you need to be able to share? Ms Challen, you're leaning in? Everybody's holding their breath here.
I think certainly it's a difficult question to answer specifically. So I think what we would want to be mindful of is the consequences of sharing information prematurely or out of context. So I think the important component would be to understand the subsequent use of the information. In terms of the timing, certainly we would make our own assessment, as we do in the cases we manage already, as to the risk that it poses in the immediate sense.
Which you would discover yourself? Would you ever be able to get information from DSS or Services Australia in a timely way to help give you the heads up?
Well, at the moment, I think that would be limited to what we've previously indicated is available.
So separation,
yeah, absolutely. There are currently that there is the separation in that context. I think for us certainly that there might be a distinction between professional misconduct as compared to concerning behaviours that we see. So within the administration of tax, we would act on concerning behaviours and how that, as I said, how that presents within each of our risks. I think we'd need to properly understand what broader risk we were assessing to identify the appropriate information to share. But beyond that, it would largely be with regards to the actual ability to share that information outside of the existing privacy arrangements. Is probably what I would say. I think we would probably want to have more time to have a considered conversation as to what that would look like across each of the agencies and ensure that it met the intended result for the intended people.
Yeah. And I appreciate your caution there. As I've indicated before, people need that privacy, but given the reality, 88% of women respondents to this inquiry from Swinburne had reported someone controlling their money or finances over decades or years, and 80% of women reported that their ex-partner had replaced physical abuse with financial abuse via child support, which absolutely involves you, and then pretty likely, in the worst cases, is going to involve the family court. It seems to me there needs to be an ecosystem of information sharing that is a dissuasion from undertaking the kind of behaviours that are being reported publicly and in the course of this inquiry to us, which are profoundly unhealthy and have long-term intergenerational damage. So can I ask you to all take on notice, what sort of recommendations do we need to have? Is it a task force that needs to be set up to look at, the nature of information sharing that would be both protective and appropriate to deal with the context that is now known in the public place, which is quite alarming and quite different from what has been discussed in the public until recent times. So that's a question I notice to you. The tactics of financial abuse are recorded here on page 4 of the submission, I believe, from DSS. Tactics of financial abuse included with deliberate withholding of non-payment of child support, which we discussed, deliberate minimisation of child support liabilities, we've discussed, threatened with their children not being returned, which we haven't discussed, but gives shape and, I was going to say colour, but we don't want to call it that because that's a nice term, shape and revelation to the nature of the intent of these malign actors in our community. Excessive court actions, threats of legal action, which we've discussed somewhat with you. Then finally, reported or threatened to be reported to government agencies as a way to cause financial harm. How are your systems being used to cause financial harm by the perpetrators? Like, what does that mean? Reported or threatened to be reported to government. What is a perpetrator doing when they use those hotlines that are set up to actually supposedly get the baddies, but it's the baddies using them to get the goodies, if I can put it in that way? Like, how's that operating and what needs to be done about that? Who'd like to speak to that from the ATO? Ms Challen.
I might start and others may have more to add. So certainly I'm not sure that we have specific evidence with regards to the number of instances where our hotlines would be used. We certainly do, and Farish might have more to add, we certainly do see instances of both genuine cases coming forward with regards to financial abuse, as much potentially we also though see those that are not genuine cases of financial abuse but are presenting as such, and obviously depending on the subsequent implications to the other person, there may actually be almost a reversal in terms of impact. I don't know if you want to talk to that.
So Miss Ali, can you give us an example of this to flesh it out, because we're talking in the abstract here. And, this is a hearing for the public to understand, and they don't have all the chapter and verse on ATO rules, etc. So what does it look like when somebody abuses the ATO hotline in a way that is damaging for somebody experiencing financial abuse?
So this is not specifically hotline, but ATO systems. Yep. We have recently had cases where people will fraudulently register an ABN and obtain a GST refund. And they will do it in other parties' names. So we have had genuine cases where spouses have imitated, the abused spouse and obtained a refund, and we've in those cases had to reinstate their identity, give them new identifiers, and rectify things where it is. So that's probably an example of
a very good example, and it gives shape and form to the statement we heard. You will never get away from me.
Yeah, but in those
this
cases,
will never stop. Is the threats that were reported to us earlier today?
Yeah, and where someone has fraudulently imitated someone, we have been able to reverse that and put them back in the situation that they are. But that's probably an example of where.
And how long might such a process of redress take?
It's there's obviously a little bit of a disconnect between the victim finding out that it's happened, yes, and the perpetrator getting and doing it. But it can be days, weeks or months, right, depending on what the fact pattern is.
Okay.
Most of the ones we've seen, because it has taken action on our part because we've detected the fraud, I would generally say it'll get resolved in a couple of months.
Could there be fraudulent activity that you're not detecting?
There could be. We do make every attempt to detect it and to deter it, but I would, there are imperfections in everything.
So identity theft is at the heart of that one?
Identity theft, we also have categories of cases where people are complicit and where they have alleged coercion, where they've been coerced into doing certain actions. Those are a lot more complex.
And could you take on notice how often they're resolved in favour of the person who has been abused, and what sort of redress there is for them, and what sort of punishments there are in place for those who have perpetrated such fraudulent and abusive activities? Thank you. Ms Miller, did you want to say or add anything on any matter? You've just been here. I don't want you to miss out on having a turn. It's nothing?
Nothing. No.
Okay, thank you. Same question to each of the entities, and this will be the end of our discussion, but please do expect questions on notice. How are your systems? How have you found them being abused, and what have you been able to do as corrective action? So we get the shape and form of what people are trying on.
So the example that popped into my mind around that would be when they were actually a couple and the perpetrator has forced or encouraged or coerced the other person to provide incorrect information to us, which may have a financial benefit at the time. So, depending on what that information could be, and then when they separate, know full well if they tell us the actual problem that's happened or the actual data, that it could result in a debt for the person. In those circumstances, they'd be the ones that we would be looking at to say, can we identify that this has been coercive behaviour and therefore the debt would not actually be raised against that individual, but they may not know that at the time.
Yeah, exactly.
So that's
So this could be part of the long-term setup. I mean, and that's the other shocking thing, that we actually heard evidence that there are men who are actively going overseas and seeking partners to line them up, observing the financial wealth of their parents to get the whole benefit, right? So really malign actors that use every possible strategy to get the money in their own pocket, and they don't care who they hurt along the way. So that's a very interesting one. What about from the Attorney General's?
I think I'll just reiterate that our submission and our comments today articulate a range of different reforms and programs that are in place to support people engaging in the family law system. I would note that one other aspect we didn't cover today is we do now have the National Information Sharing Framework, which means that the court can seek information from police agencies, firearm agencies and child protection agencies, and that can bring to the court's attention a range of different things, which can include perpetrators making vexatious complaints to, say, child protection agencies, etc. So it gives them the pattern of information so that the court can consider risk and make...
So the police can provide that to the court. Do the police need to be able to provide that to your entities, your agencies? Do you need access to that sort of information?
I would say, Senator, it would certainly be helpful in terms of the identification of cases to use the existing systems that are in place.
Because the interaction with you would occur
available
before it gets to a court, so we're further down the track by the time the police are informing the court. So potentially police could inform the ATO and there would be a flag, which then may or may not be useful in the case of some concern. Mr. Thompson.
And Senator, I think this is kind of... The ATO has been thinking about this in terms of our role as the administrator, but our role in a larger system, in that there may be other partners in the system, both government and non-government, that are better placed to identify when someone is facing financial abuse or is experiencing vulnerability in some other format, which I think is probably why, when you asked us what we needed, it's a matter for Treasury in terms of change, but I think there's the complexity in this system around who's the right people to get information from, who's best to make that assessment, but then also these bits that you mentioned before about we want a well-designed system, though, that then isn't used by the perpetrator to create further financial abuse. And I think that complexity is
so
probably
flags
why,
rather than actions seems to be the first thing that needs to happen.
Yeah.
So that there's something that follows people around in the system of have a bit of a look at this, not an accusation, but there's a flag that's there. I mean, credit rating agencies are profit-making ones, right? And they've got all sorts of information that they're sharing all of the time. You don't get to see that, you know, which is kind of pretty interesting because it's very revealing from what I understand. Did you want to add anything?
No, I think we were all of the view that we do have a close relationship with law enforcement now, but usually from the perspective of fraud and other things. Yeah. So I'm not quite sure what other information we're already being received, but I agree with my colleagues. There is always help in targeting where you may be looking.
The ABA have recommended consideration of an amendment to the Privacy Act to permit good faith disclosure of information to law enforcement or adult safeguarding authorities. Does that include you? Are you adult safeguarding authorities?
No, that would be a reference to the state bodies that have been set up to consider issues around the welfare of people, so guardianship type bodies or the adult safeguarding unit that operates in South Australia, for example.
So do you need disclosures of the kind that the ABA are recommending as well? Again, as flags? Do you need to be able to talk to each other and others more freely than you currently are to provide protection, really? There's heads nodding. Because there are barriers to information sharing. So many more things to ask you, but can I thank you all for your submissions? And, you know, the thing that visually, just I've been thinking as we're sitting here that there's so much information there. There's so much information there. So much information there. And there's so much information in other parts that could be providing protection to very vulnerable people in our community. And in the middle, you know, we've got all the light here, but it's kind of like there's a dark space right in the middle of all of this where women and children are suffering profound forms of abuse post-separation that involves banks, insurance agencies, governments and lawyers, legal practitioners and accountants. So I look forward to your responses to the questions from the committee, and we'll do our very best to put on the record some recommendations for improvement, you know, some light in that darkness so that people have a better chance to get on with their lives without the suffering that now is, you know, a stain on our national identity, I think. So once again, thanks for your work as public servants. Thank you for being here today. And that will bring the day's inquiry to conclusion. Thank you to all the witnesses who've appeared today, to Hansard Broadcasting, and of course to my colleagues for their attendance and their great questions today. The committee now stands adjourned. Thank you.